constitutional issue separately, but is that there was a loan that he received from his mother after he was in the runoff for, it was $30,000. Completely, we have had several cases involving those kind of loans, undisclosed, and continued to be undisclosed even after the JQC started to investigate. On top of it, it's unrefuted that after he was on the bench, he represented himself as an attorney in dealing with his mother's, I think it was either a foreclosure action. So we just don't have these personal issues regarding employees that occurred in the course of his being a judge, but we also have what has been, in many cases, significant reason for either sanctions or, in some cases, removal from the bench when coupled with other issues after someone has taken the bench. So we have the loan, unreported, plus practicing law, together with these issues involving the employee of the clerk's office.
Sure. Justice Pariente, Judge Turner acknowledged those errors, number one. Number two...
Well, when did he acknowledge those errors?
First,
see, the problem is, are we saying that all a judge has to do, who has the sacred trust of his or her community, is after he's been found out, say, gee, that was an error, and then we'll just let him continue or her continue to stay on the bench?
No, Justice Pariente, not at all. What we see, though, is that as a mitigating factor when it comes down to this court's determination of punishment of a judge, that the ability to recognize those errors and to show remorse actually reflects positively on the issue of mitigation.
At what point was this done? I mean, he didn't just say, I'm going to, sign up and represent his mother. How long did he do it before there was this remorse?
Well, I think, Justice Quince, that on that issue, with the underlying circumstances, first, with regard to, he did report the loan immediately. He reported the loan without anybody prompting him. He reported the loan. He reported it as a loan, actually, on his Form 6. That was initially done. Now, getting to your point, Justice Quince, he represented his mother for approximately a 2-month period. That representation, which was initially transactional in nature, started after she had lost everything in the Bernie Madoff scandal.
Let me ask you this. Is there any indication in this record that he did not know that he could not represent a client while he was a judge?
According to the testimony from Judge Turner, and which is the only testimony on this issue, he misread the rule. Similar to how Judge Kolodny had misread the rule on the statute under 106.075.
And that statute says what?
We're dealing with 106.075?
Yes.
It deals with the reporting requirements under Florida election law as pertains to...
So you're jumping from election to the representation. I'm talking about the representation of a client while he was a judge.
Sure. He believed, based upon his review of the canons, that he could represent a family member. Now, that same canon is limited to...
if you read that canon and the commentary, it is crystal clear that the conduct which he engaged in was inappropriate, isn't it?
He misread the canon.
Well, but I'm saying, if you read it and you understand the English language, there can be no doubt about the meaning of the canon and it proscribing the conduct of negotiating that he engaged in.
The canon does not seem to prohibit negotiating on a transactional issue. And if we review the underlying evidence here, dealing with the correspondence that was sent first to the mortgage broker and then later on to the foreclosure prosecution attorney, it reflects that he had represented himself as the son of his mother, as a non-practicing attorney, because he was trying to avoid even that collision. But at the time, he was panicked, and there was a 2-month period where nothing happened, where he was attempting to...
The commentary to Canon 5G, which is the canon at issue here, says, a judge must not, however, act as an advocate or negotiator for a member of the judge's family in a legal matter. What could be clearer than that?
Mr. Chief Justice, he misstepped. And
Can I go back to another
Yes.
something you said, and I want to make sure you have a chance to correct it. Did you say that Judge Turner actually did report the $30,000 loan on his Form 6?
He reported the loan of approximately $44,000 on his Form 6, and then whereby he lent from there $30,000 to his campaign following the election.
So when the JQC found that Judge Turner had drafted his own Form 6 and failed to report the $30,000 on either form, and he didn't list the $30,000 as a gift on his June 2009 gift disclosure form, or report the funds in any tax return, that's not correct?
I believe that JQC Exhibit Number 1 actually provides the proof by which I'm referring. He reported it. He reported it. Did he make, after it became a gift instead of the loan that it initially was, did he re-report it as a gift? No, he did not.
Okay, what form did he, so again, because this is a very important thing, you're saying that he did not accept a campaign contribution of $30,000 from his mother in violation of Chapter 106?
He accepted a loan in excess of $500 contrary to 106. He reported that voluntarily without being subject to any JQC investigation.
That's what I'm trying to understand. He reported it on his Form 6 as a loan?
He reported it on his Form 6 as a loan.
In what year?
This was immediately following the election, immediately upon he found out that he needed to do that.
Okay, I just want to make sure. The JQC found that he drafted his Form 6 and for both 2009 and 2010 failed to report the $30,000 on either form. Is that incorrect?
He did not report it as a gift. It transitioned from a loan to a gift, but he reported the initial loan. And he reported it as being from his mother, and he reported it voluntarily without being under any JQC investigation.
What's the date of the form that he made that report?
And with whom was it filed?
It was November of 2008 that he initially reported it, and it is under JQC Exhibit Number 1 to these proceedings.
Counsel, you're now down to 5 minutes, so
Okay,
now starting to use rebuttal time.
I'm sitting down. Thank you very much.
May it please the court. My name is Marie Tomasi. I have the honor of sitting with Marvin Barkin from Trenum Kemker. We're here on behalf of the Judicial Qualifications Commission.
Maybe you can address the last point first, because I'm a little confounded. Obviously, that's a serious charge and finding, and I want to, if he reported it, then it's a non-issue.
Your Honor, in the findings of fact from the hearing panel on page 13, the hearing panel found that Judge Turner reported to the Department of Elections a, quote, loan from his mother to himself personally and loans from himself to his campaign, and cites to hearing panel Exhibit 3. And I apologize that I do not know the date of hearing panel Exhibit 3. It is, I do not believe, a Form 6, however, because at the bottom of this page, and repeatedly in Judge Turner's own testimony, well, at the bottom of this page, the hearing panel found that he did not report on his Form 6 for 2009 and 2010 this loan or liability.
But if it was reported in some official form, isn't that then evidence that he wasn't trying to conceal it, and doesn't that mitigate the significance of the violation?
The hearing panel rejected that argument, Your Honor, because they found that it was not believable that Judge Turner, who was such a was so persistent about exactness and correctness with his judicial assistants and with his other affairs, and who had an advanced degree in taxation, would not know to include it on his Form 6s.
Well, the Form 6 is what, after this is after he's elected?
For 2009 and for 2010.
Okay, but what I'm going back to is during the election. One of the reasons I always think that it's something that the elections that you want to know is because the opponents want to understand if someone has a source of money that if they're loaning it from themselves or they're accepting a loan. Are you saying in all those during the election, he did everything properly?
No, Your Honor, and I think the testimony of Judge Turner himself reflected numerous errors and omissions in his various filings throughout the time, both preceding and after the election. And in fact, this was of grave concern to the hearing panel because they did not understand why he never went back and corrected them and why there were other inconsistencies in between one year to the next on the forms that were troubling to the commission or to the panel. Of course, you also have the problem that even if it's disclosed, it's in violation of the limits, and that becomes an issue as well.
But in trying to distinguish, we have a range of these cases where people take loans, they're boyfriends, they're, different people, and I don't know if in each situation somebody the law is more confusing than it needs to be, or we're not doing a good enough job of explaining it. But standing alone, would that, what he did with reference to his loan from his mother, would that warrant his removal from the bench?
Your Honor, under the existing case law from this court, I'm unaware of a case in which a single violation related to a loan that had been reported on one form but not correctly reported thereafter would constitute grounds for removal. But respectfully, the court need not reach that issue because there were so many violations
here. Okay, so
here.
give us, in terms of the, we've got an advocate for Judge Turner who is saying, listen, this judge performed wonderfully on the bench, that there is, I'm not sure of course we're not talking about a lot of years here, he just was elected, but and doesn't have any of these violations relate to anything he did on the bench. So, and I know we have removed judges even if it hasn't related to their conduct on the bench. So give us what the JQC goes from the worst thing for the public, if the public is hearing this, what's the worst thing and what's the combination of everything? So start with what you find and what the JQC found to be the significant violations. And I understand they're all significant, but you understand.
I think I understand the question, Your Honor, and if I don't answer it, please tell me. But the common thread in the removal cases is the public perception in the sense that the judge lacks the ability to maintain the public confidence and to fulfill the tremendous duties and responsibilities and to fulfill the public trust of the position. In this case, to me personally, and I believe to the Judicial Qualifications Commission, the most troubling allegations were about Ms. Shelby, and that occurred after Judge Turner took the bench. That conduct was, perhaps in teenage vernacular, creepy. It was very hard to understand his interest in her 12-year-old son, which Ms. Shelby clearly found to be very upsetting and distressing. It was very difficult to accept the explanation for this behavior from a man who is a professed expert in employment law on the plaintiff's side, that he didn't know that he'd crossed a boundary, that he didn't realize she might be afraid of losing her job. That was not credible to the hearing panel. The intrusive nature of that conduct was extreme. It was pervasive. It's hard to imagine.
How long a period of time are we talking about that this intrusion in Ms. Shelby's life took place?
About a year, Your Honor.
And from when did he assume his position as a judge?
I believe that would have been January in the year that preceded his March stepping off of the bench, being removed, and I use that word incorrectly, but being taken to inactive status. This chief judge removed him from active status based on the conduct regarding Ms. Shelby? I believe because of this proceeding, Your Honor.
Well, that doesn't usually happen, and it's an unusual situation for, usually judges remain on the bench. We didn't remove him, but it wasn't, I don't think, a voluntary situation. But I may be mistaken.
Not to my knowledge.
But so really,
no.
what we're talking about is he only served as a judge for a year?
I believe it was 14 months.
And of that time, he was harassing Ms. Shelby for almost the entire time?
I think her testimony was that it began in a few weeks or maybe a couple of months into his term. So I'm saying about a year.
So, and
using
during that
roughly.
time, he also succeeded in practicing law for his
Well, and
mother?
this is the other problem. We have two sets of facts preceding Judge Turner winning the election and taking the bench, right? The campaign financing and the direct solicitation of funds. And then we have two sets of facts that got that were violations that came after he took the bench. And one was Ms. Shelby, and the second was acting as a lawyer representing his mother in the mortgage foreclosure and preceding the mortgage foreclosure. And this is where we getting back to the ultimate question about removal. This is where the problem lies. You don't have an isolated, oops, I forgot to report that, or I reported that incorrectly on my Form 6. You have, I did not comply with the campaign finance requirements, reporting requirements, or more importantly, with the law on campaign financing. I directly solicited funds, even though I knew that I was not permitted to do that, and I tinkered with the language of the email trying to make it better, but I still sent it. And then you have, now I'm on the bench, and I'm encroaching on this woman's life in a way that any objective person would recognize was inappropriate from a superior to an inferior employee.
So during this period, which is very troubling to me, the incidents with Ms. Shelby, did she report this to anyone, or what? I mean, so a whole year went by, or approximately a year, and these things were going on, and she was saying nothing to no one?
She talked to a confidant at the courthouse whose name escapes me, and I believe she was a judicial assistant or perhaps another clerk, that she talked about how she felt uneasy. After the incident in the gym shorts, this was a woman that she went to and said, you know, I'm uncomfortable. But essentially, she did not report it up, if you will, and did not apparently seek any help for it in the beginning. Of course, it was something that everybody knew about. They had to move Miss Shelby's desk. They had to change her phone number. She used to hide from Judge Turner. The testimony was when he would come to look for her, she would hide in the shelves of filing cabinets, and he would look for her. So someone described it as hunting for her. On the final occasion in March, I believe it's Judge Perry, the chief judge of that court had to call Judge Turner on his cell phone and say, stop looking for Miss Shelby. It's getting you in more trouble with the JQC. I mean, this was not unknown to the people at the courthouse, and it's certainly not the image of a judge that the state of Florida wants to convey to the public.
Is the JQC here also, though, to defend the constitutionality of Canon 7C as applied in this situation? We have something where the judge in the email says, if you would consider making a contribution to my campaign to help me communicate my message, please let me know, and I will have someone from my campaign finance committee contact you. So if he had said, I have a campaign, said everything else, but I have a campaign committee and they will be contacting you, it would be okay under 7C, but it's because he said if you'd consider making a contribution, that's the violation. I mean, in other words, I think of this one, this is, I think there's some problems with 7C. Certainly the 11th Circuit has held it was unconstitutional as regards the Georgia law. And, he's not a sitting judge. He's writing a mass email. And we know that what happens, especially in these local elections, is judges go to campaign events, someone raises money for them, and then after the fact, they're thanking everybody who raised the money. So it's a bit of a, it's practice in a way that seems like it doesn't really fulfill any meaningful purpose to begin with. So, not being narrowly tailored is my concern. And also in this situation, It really is just a question of a couple of words being a little bit different. He's not going out. He's not on the bench calling lawyers and saying, please contribute to my campaign, which is the real problem. We're sending letters to people appearing in front of him and saying, contribute. He's sending out an email, and then he's telling people, you call my campaign committee. So help me, first of all, with what's so bad about what he did, and how is that, if we, is that really a narrowly tailored canon if it could apply to something like this?
The problem is judicial candidates cannot directly say, please give me some money and support my campaign. That's why you have to have a campaign committee, and they have to go raise your money for you, because Florida has a compelling state interest in protecting the integrity of the judges.
And I understand that it could be, again, with a face-to-face solicitation of lawyers who are likely to appear in front of you. It's sort of like, I can't say no. On the other hand, the campaign committee, consisting of lawyers that appear in front of you, go and solicit the exact same lawyers, and you, the judge, know exactly who has contributed to you. So it seems somewhat meaningless, and it's, I don't know, I'm not as concerned about the First Amendment issue as I am, how does this really help maintain the integrity of judicial elections and the judiciary?
I think the sad fact is that as long as we're going to elect judges, you're going to have fundraising, and it has to be done in some manner. And so this is the scheme or the system that's been set up to try to put at least some insulation between the direct ask by the judge and the direct response by the asked attorney.
So I guess your argument really is that a person is more likely to give if the judge or even the potential judge is the one who is personally soliciting, even though the judge knows that someone else may be soliciting, that when the judge, himself or herself, actually does it, that is the real difference?
Your Honor, yes, that is certainly part of the difference. And the other part is the appearance of a quid pro quo. The problem with that is exactly one part, and the other part is the problem with the perception that if I am a judge and I ask you for money and you give me money for my campaign, that maybe the next time when I rule in your favor, I did it because I remember that you answered my direct request and gave me money.
Again, but we're not naive. I set up my, the person who is my best friend in the circuit, who is actually recused on my cases. And that person is my right-hand person. And that person goes and says, Judge Pariente is up again for election, and we really need you to up again with the $500. I mean, I understand in Miami-Dade, everybody then contributes. I mean, it's not a... So what I'm saying about it here, it is not that he personally solicited face-to-face. He said, if you'd consider making a contribution to help me, please let me know. That's where, and I'll have someone from my campaign finance committee contact you. So am I correct that if he didn't say, please let me know, if he says I'm running and somebody from my campaign finance committee will get in touch with you, there would be no violation?
The problem with this email is exactly him saying, please let me know. And
Okay,
I'll
so
get
if
you
he
in
didn't
touch
say
with somebody.
that, then there wouldn't be...
I'm not prepared to concede that on behalf of the JQC because I don't know. I haven't seen that case yet. I think the judges are not supposed to ask directly for support in any regard, for financial support. They can go to the events, they can have their committee do it, and I know there's some artificiality there, but it's the best thing we can do with elections.
On this, wouldn't you concede that the broad prohibition on solicitation that we have adopted is inconsistent with the view of the majority of the federal courts that have considered the constitutionality of this?
Oh, no, Your Honor, I wouldn't concede that because you have the Seifert and Bauer cases that we cite in the brief from the Seventh Circuit that have upheld a very similar canon to ours. You have the Eighth Circuit where they've ruled against us, but that panel decision is up for en banc review, and it's been there a long time. I don't know what that means, but we don't know yet where the Eighth Circuit stands. The
11th Circuit has ruled it unconstitutional, and the Sixth Circuit in Cary, an
Agreed.
identical provision, correct?
Agreed. So I think we're maybe going to be even, because I suspect the Eighth is going to come out in our favor. Maybe I'm an optimist. But the 11th Circuit opinion, respectfully, the Weaver opinion we submit is wrong.
I guess this is the thing, and of course, it's our canon, so we can look, of the 50 states that and I guess all of them have some form of a canon like this, is there, and maybe this isn't the time to do it, it seems that there is a difference between the face-to-face solicitation of a sitting judge of a candidate for money versus a general campaign letter saying, I'm up, I am going to need money, and people from my campaign committee will be contacting you as a general way to know that the judge is needing the money.
There has been discussion in the cases of distinctions between in-person solicitations, email, which is more personal than a mass mailing, but less personal than a face-to-face, and mass mailings. And certainly this court has the power to review the canon and change it. But we submit that as it stands now, it's constitutional.
Is this consistent with the ABA model canons? Or is it harsher?
It is. I was just verifying it is consistent with the ABA panel, with the ABA model canons. And respectfully, the Weaver decision was issued 6 years before. Our canons were amended and revised 6 years after Weaver, and this canon didn't get changed then. And the Weaver case was issued based on the White decision out of the U.S. Supreme Court, but now the U.S. Supreme Court has given us Caperton, where they've said the public has a compelling interest in the integrity of judges, and judicial elections are not the same as legislative.
But isn't that a bit of a stretch? Because a lot of that money, that wasn't about solicitation. A lot of that was independent expenditures, the separate organization spending the money, and that wouldn't have been affected at all by this sort of restriction.
No,
correct?
I'm certainly not suggesting that Caperton is dispositive of whether this canon is constitutional.
In fact, it makes we got a mockery potentially of judicial elections with independent expenditures from other groups to overshadow and raise millions of dollars, and we're telling our own judges they can't do something to keep their seat. They have to go through this artificial campaign committee. I'm just not sure it's consistent with where the U.S. Supreme Court is going for sure.
Well, now you've gotten into the independent corporate-funded donation cases, but the statements in Caperton that I think support our position here are the ones about the importance of judicial election integrity and the perception of the public. And just to loop it back here, that's one of the key problems here on why removal is required, because there is no doubt that with 4 separate factual situations giving rise to multiple canon violations, that the public perception requires removal. This court's own precedent.
You're now about a minute over.
Oh,
so
I'm
you
sorry,
need to
Your Honor. Then I will
conclude.
sit down. Thank you so much.
Thank you.
Briefly, I would like to touch upon the issue that we left off with opposing counsel. We're discussing Canon 7C, specifically the no solicitation clause. Weaver v. Bonner, we would argue, is controlling within this
But
jurisdiction.
in this situation, again, a judge who he knows the canon exists. He doesn't bring a declaratory judgment action to declare that canon unconstitutional. In fact, he works on the email, and there's no question that the email is a violation of 7C as it stands. So here is a judge sort of taking the law, or about to be judge, into his own hands, saying, well, I know it exists, but I'm still going to I'm still doing this. I'm still going to, and then it follows with the whole theme of, and I'm going to still practice law, even though the canon clearly tells me not to practice law. And then the situation for you to tell us that he hasn't had any issues when he was a judge, when he sat as a judge for 13 months, and most of the time he's harassing a courthouse employee that has put the whole Ninth Circuit into a tizzy over it. Really sort of doesn't give the correct picture of what was going on with Judge Turner.
Quickly, Justice Pariente, he acknowledged that he violated Canon 7C1. He had an experienced campaign consultant who initially started this one, and he did tone it down, but at least we know that based upon the current language of 7C1 and based upon Judge Turner's admission, early admission, that he violated this canon. I think it's important for this court to understand the underlying facts behind the conduct alleged against Ms. Shelby. First of all, the testimony in this case is not that he had an interest in Ms. Shelby. Ms. Shelby's own testimony states that he had no sexual or romantic interest in her whatsoever. Judge Turner is a cancer survivor.
Think of this idea that there is a young woman who is having to hide from a sitting judge, and everybody in the courthouse knows about this mockery, and it takes the chief judge to finally say, stop it. You've got to stop it. It is inappropriate. And he continues. And he has to, and the chief judge takes the extreme step of, after these charges are filed, of removing him. How do you put a judge like that back on the bench when the credibility within this Ninth Circuit has also been destroyed? And do we consider that at all? Is that something we should look at, that it was pervasive and it was known by employees in the courthouse?
Justice Pariente, Judge Turner did not know about it. He did not know about it. Ms. Shelby's own testimony states that he did not know about it. It wasn't until March of 2010, when he was removed, that Chief Judge Perry came to him and even told him about what was happening. As soon as that happened, the testimony supports from the JQC's contested hearing, he had no further contact with Ms. Shelby. The interest that he had was with Ms. Shelby's son, who was also suffering cancer. He was removed. I mean, I would think at that point, even a pathological, serial, psychotic criminal would know, they better stop their activity. I mean, I don't... Judge, if people knew about it, nobody told him. And he did have boundary issues that he sought to redress, but it was the interest in the son who, Judge Turner is a survivor of prostate cancer. Ms. Shelby's son, Christian, was going through not just non-Hodgkin's lymphoma, but a remission into non-Hodgkin's lymphoma, and that spurred Judge Turner's interest. He had already been qualified as a hospice volunteer, and can we say that maybe he overstepped? Perhaps he overstepped, but Ms. Shelby never told him that. Nobody ever told him that. In fact, from what we have in the JQC testimony, which I urge the court to review to determine whether or not there's clear and convincing evidence, especially sufficient to remove this judge from office, there's nobody in the courthouse whatsoever, whether it was Ms. Shelby, this clerk or JA friend of hers, Judge Margaret Waller, who according to Ms. Shelby's testimony supposedly knew about this at the end of 2009. Nobody went to Judge Turner and said, there may be a problem here, just stay away from her. Judge Turner found out about it in March of 2010 when Judge Perry told him about it. And it wasn't that he was stalking, contrary to what the JQC put into its brief. This is not a stalking issue. This is somebody who is perhaps overstepping the bounds of caring.
But why was she hiding if this wasn't a stalking issue? I mean, you make this, you're attempting to make this sound like this was some ordinary thing, but for someone to feel so compelled to hide from a judge who's constantly looking for them, that to me is not some ordinary interest in someone.
Judge Turner's actions were unknowing. He was not attempting to seek her out for any ill-reputed purpose.
But
he was seeking.
Matter why, if he's constantly doing it and she's having to hide.
According to the testimony of Barbara Mara, he had boundary issues that as soon as Judge Perry brought it to his attention, he saw Dr. Mara, he saw the follow-up psychotherapist.
He has boundary issues. Had this kind of conduct happened before?
No,
Or
no, Justice Quince. No, it's never been brought to Judge Turner's attention that he had boundary issues. As soon as it was brought to his attention, then he said, okay, well, I've got to see Dr. Mara. And then upon Dr. Mara's referral to this other psychotherapist, then he continued that counseling through the pendency of this case. So we know that he took...
Counsel, you're now
rehabilitative steps.
a little minute, more than a minute over, but you can finish up in about 15 seconds if you would.
Thank you. What this reflects is we see a judge who made mistakes, who has acknowledged those mistakes, who sought rehabilitation with regard to his boundary issues. And does this require removal from office when you show no corrupt or ill motive, when you show nothing that impresses upon his actual conduct and his ability to serve on the bench? Then this requires, and we would argue that the court should depart down from the JQC's recommendation of removal and instead impose a public reprimand upon Judge Turner. Thank you.
Thank you. We thank both sides for your argument. The next case on our docket will be Delhal versus the state of Florida. Counsel, you may proceed.
Good morning. May it please the court. I'm Melody Smith on behalf of Widado Delhal. Respectfully request that this court reverse Mr. Delhal's convictions and sentence to death. Widado Delhal was convicted of killing Hubert McCrae, a state witness who was to testify that Mr. Delhal's brother, Negus Delhal, killed Gilbert Bennett, also known as Richie B. There were no eyewitnesses to Mr. McCrae's murder, no forensic evidence implicating Widado in the crime, and the circumstantial evidence that the state harvested required a confession to persuade Widado's jury to convict him. I'm going to refer to Widado Delhal as Widado because there are 6 Delhal brothers, and we may be talking about a variety of them. The trial court denied Widado's pretrial motion to suppress his statements, which he had retracted, and then permitted the state to repeatedly attack and destroy Widado's credibility and character, to continually mislead and inflame the passions of jurors, and to frequently ignore this court's admonitions against using overzealous prosecutorial tactics. Today I intend to address claims 1 and 2 and 5 and briefly 9 and 10. I request rebuttal time beginning with claim 2. The trial court permitted the state to present evidence about the Bennett murder over defense objections. The state filed a notice of intent to present bad act evidence, specifically all the facts and circumstances in the Bennett murder, citing Williams, and the trial court conducted a hearing prior to trial. The state argued that because Widado retracted his confession, what the judge termed his so-called confession, in volume record 112, transcript 83, the state had to prove the confession was not false for 3 reasons: to prove the facts of the Bennett case, to prove the aggravator, eliminating a witness, and to show motive. The defense argued that the evidence showed the motive may be relevant, but that all the facts, if admissible, might make the Bennett murder a feature in the case. The trial court ruled that it would permit the state to introduce only evidence from the Bennett murder to show motive. and warned the state not to cross the line. When the state not only crossed the line but removed it, as it called 4 witnesses to testify about the Bennett murder, showed a photograph of the bloody torso to Widada's jury, the trial court improperly permitted the state to present irrelevant evidence that did not show motive, permitted the state to present extensive evidence that did not show motive, and permitted the state to make the Bennett murder a feature of the trial.
Well,
The
what
questions in
evidence-
case law,
What exactly, what are you saying was introduced that was irrelevant to this case?
in this case, there was testimony about the crime scene. 4 different officers testified. There was fingerprint evidence admitted. There was that picture of that bloody torso of Mr. Bennett's body. The state constantly talked about the Bennett case. When you hear this argument today, you're going to wonder, are we talking about Mr. McCrae's murder or or Gilbert Bennett's murder?
Okay, now
Because-
why would the fingerprints not be relevant, not be admissible in this trial?
Thank you, Justice Lewis. Our argument is that this so-called collateral evidence that the state was permitted to introduce to Widada's jury, we're asking what actually showed that Widada had motive to kill Mr. McCrae. Remember, that was the trial court's decision. How do the fingerprints show motive?
Well,
What do we
doesn't
need to
it-
show
does
motive?
it- well, I'm
That's the
sorry.
question. Sorry.
But would it not place his brother there at the time of what's going on? Isn't that the purpose for allowing that in?
Well, that may be the purpose, but the purpose for the trial court to allow evidence to come in was to show motive.
Well,
And
I
that does
understand,
not
but you
show
have to
motive.
show- would you
It shows
not-
that Negus Delhal was there.
Would you not need to show, and part of the motive, as I was going through reading this, and as
Sure.
a trial lawyer, what would I need to show a jury
This is what,
that a brother was involved, that did something bad, and that there's a witness to it, and then did something about it?
Thank you,
What would I
Justice
need
Lewis.
to show? So I think that's what we need to.
Right. At the hearing, the judge talked about this. What do we need to show? The defense argued that the defense needed to show, number one, that Widada's brother was arrested for the Bennett's murder, which the defense conceded. Number two, that Mr. McCrae was going to testify against Widada. And they conceded that as well. And this is all in the hearing on this notice of intent. Then, number three, and this is where we did not concede at trial, that Widada knew that Mr. McCrae's identity, his name, and his intention to testify. This is the contested issue that requires some maybe evidence out there to show motive. The other two, the state was allowed to admit the affidavit. So clearly, everybody knew that Mr. McCrae was a witness to testify against Negus Delhal. Justice Perry?
Yes, my question, thank you. You could see my math starting to open here. In this, one of the arguments in many cases where it becomes a feature of a trial is they're trying to get in evidence of another crime that the defendant himself committed.
Correct, in Randolph v. State.
Here we have a situation where, other than the comments that you have in issue 1, which is independently an issue, I understand, the state wasn't alleging that Widada was involved in the Bennett murder. So therefore, the issue of prejudice to Widada is different than if Widada and his brother were actually committing this other murder. And so I have, in terms of, I'm not sure, and I'd ask the question, what would a picture of the bloody body, for example, that seems to me to be, doesn't go to anything
Doesn't
that
go
we
to
need
anything.
to establish. But since the state wasn't attempting to show Widada was involved in that murder, how does it really prejudice Widada if there was some error with regard to how much came in?
Thank you. During the same hearing where they were talking about what was needed to establish motive. The state told the judge directly, we believe Widado was involved in the Bennett murder. And the state says, or the trial court says to the defense.
But involved in the Bennett murder, right?
Correct.
Okay, but what in all of this evidence even demonstrated that?
That's the
If that
point.
was what the state was trying to do, it seems to me that there wasn't any evidence that said Widado was involved in this.
That's the point. There was no evidence. What
But
in
that
all
goes
the
back to Justice Perriente's question, though. If there is no evidence and that Widado was in fact involved in the Bennett murder, where is the prejudice?
The prejudice
for
is,
this
you have
information?
to almost think, the reason I'm starting with 2, you almost have to think of this as a crescendo. In 2, they're just talking about the Bennett murder a lot, opening, closing, different witness, photographs, so forth. Issue 1 is critical because at that point, and we can move to that, I do want to mention, according to case law, though, we really want to be clear that any collateral evidence that comes in has to be evidence that the defendant committed the crime.
Let me just, okay, but
Okay.
here is where you could tie it in, and then it would become problematic. The state wants to put it in for motive for the current murder.
McCrae's murder, right?
And they put in all this evidence, and none of the evidence shows that the defendant was involved in that murder. But they want to imply it. And so that's why you would say that the cross-examination that is your issue 1 becomes so insidious because
Yes.
the state, I mean, is your argument the state was trying to do through the back door that what they couldn't do through the front door, which is imply to the jury that it was more than just that he wanted McCrae out because his brother was involved, but because he knew that he was also involved in the murder?
That's correct. This is what happened. Remember,
I mean, are
when-
you making, is that your
Yes,
argument?
Judge.
Because
That's
otherwise,
the argument.
if he has nothing to do with this murder and the jury is clear he has nothing to do with it, then it really may be marginally relevant, but it's not very prejudicial. On the other hand, if they put all this evidence in of how terrible this murder was, and then the implication is not only did he want to help his brother, but he was helping himself, then they're doing through the back door what they can't do through the front door.
And the trial court assured during that hearing, assured defense, that its prediction that the state was doing just that it was going to assert or accuse Widado of being involved in the Bennett murder. The trial court said no, they will not be allowed to do that. But you know then what happened? The state accused Widado of killing Richie B. You killed Richie B. It's not an indefinite you. See you later, brother. Can you spare a
was during
dime?
the cross-examination?
This is cross-examination. He's talking to Mr. Delhal, Widado Delhal. It's not an indefinite. There was no open door created for this opportunity. The tirade was
But
just uncalled
even
for.
if we agree with you that that was a reference to the defendant, in the broader context, wasn't it clear that the focus was on the fact that the brother committed the murder and not the defendant? And then this is, if you look at it in the broader context, it looks a little different than if you look at it in stark isolation. That
Unfortunately, defendants, and we don't have broader kind. We're focused on the defendant.
You have we have
Well,
to,
we're
when we look at whether if there was an error, whether it was harmless beyond a reasonable doubt, we have to look at the broader context. We can't look at it in isolation. We've got to consider.
I understand what Your Honor said. What I was thinking about was this tirade. He mentioned the word "you" 5 times. This wasn't an implication or an innuendo. It was an assertion. It was an accusation. It was uncalled for. Now, let me talk about the state's use of Rodriguez to argue that Widado opened the door. In that case, the judge weighed the evidence, probative versus prejudicial, and looked to see how far the door was open. In this case, in Widado's case, what happened was the judge said, "Yeah, that didn't happen." He just didn't hear it.
But
In the
isn't
same
that
way, he just
also
disagreed.
something, that's an interesting comment because it kind of goes both ways. We have the Stark transcript. And when you look at that Stark transcript, it says you couldn't find Conroy Turner, so you killed Richie B., his best friend. Okay, so that looks awful. And obviously the defense lawyer he objected immediately, but then his client went on and he didn't do anything until later on when he said, someone actually cared that Richie B. was killed. You didn't figure on that, did you, Mr. Delhal? And there was another objection. So I think that is why the broader context of the cross-examination, just let me becomes important, because to us this jumps out of the page. It's sort of like one of those the golden rule arguments where someone uses you, and really in context it's not as big deal. And I'm not minimizing this necessarily, but other than that cross-examination, did the state return to that in the examination of any witness about the Bennett murder, or in closing argument? Was there any implication by the state in closing argument or through any other witness that this defendant, Widado, was involved in the Bennett murder?
Once it accused him and used the word you 5 times, you're right. We look at it and it's
I think that's
very
an
clear.
easy.
But
let's
here's why it's not easy.
No.
Here's why they did not bring it up. I don't believe in the closing. They did not bring it up again because there was a motion for a mistrial and the judge denied it. But this is what is troubling.
Okay,
This
so I just
prediction
want to
was
make
made.
sure. Can we just?
Yeah, I'm sorry.
I'm sure it wasn't in closing because you were a good lawyer. You would have brought it to our attention. So this is why we get back to the question that if it's error, it was objected to. It wasn't immediately brought to the judge's attention. So the question is, under the harmless error standard, how would you argue that it is not harmless beyond a reasonable doubt? And I realize it's the state's burden to prove it, but
Right.
what your best take on that?
Justice Premier, the trial court was on notice. The state asserted it during the hearing. The defense predicted this was going to happen. But when the statements were made, the judge didn't hear them. And then denied the motion, didn't weigh any evidence, didn't see if it was probative or not, or prejudicial. There was no analysis.
Did anyone
So
ask
the
for
harmless part
did,
is...
Did anyone ask for any kind of I guess because he was denying the motion for mistrial, was the jury ever instructed that the purpose of the evidence of the Bennett murder was to show motive, and that and was the jury given any clear statement at the request of the defendant that the state is not alleging that this defendant was involved in that murder? Did
No,
that ever
Justice
happen?
Pergenti. Not
Never
in my
happened?
thorough reading of the record was that ever
Did the state ever,
provided.
I'm sorry, did the defendant ever, and I realize sometimes we say the defendant's supposed to do all these things, but I'm assuming the defendant didn't ask for that?
No, Justice
Well,
Pergenti.
so okay.
So the remainder of the evidence concerning the Bennett murder pointed to Negus, is how you pronounce his name?
Negus.
Negus. Pointed to Negus as being the person arrested for committing the murder and the person convicted for committing the murder. So the entire evidence presented with reference to that particular murder in 1998 pointed in the direction of the brother. The only reference made in relation to any involvement on the part of your client in this case was the prosecutor's one question during cross-examination.
It wasn't a question, Justice. It was not a question. It was a statement. It was made 5 times. They used the word "you" 5 times, and if you were there, you would have heard the screaming. And the later in, it wasn't in closing, but they did very clearly in closing more than 30 times use non-statutory aggravators to discuss Widado's future dangerousness, that he can't be fixed, that his whole family is no good. We're going to hear about that in, when I talk about the end of the case. So,
And all that evidence was, of course, independent of your client's written confession. I know you're challenging it, and he later recanted, but your client's written confession that he did the killing and he did it to protect his brother. I mean,
the state, because Widado retracted his confession, stated during the hearing that it needed to prove the Bennett murder. It needed to prove motive. And again, trial court was very clear that the state was not going to accuse him of being involved in the murder. And the state, again,
So are
Just
you telling me
refused
that
the
when all
election.
this evidence of the Bennett murder came in, that the judge never, the jury was never given an instruction as to why it was coming in? It was coming in to prove motive and not to prove that the defendant had anything to do with it? I mean, that's the normal, normally when collateral crime evidence comes in, there's a standard instruction. And that was
But
not.
it wasn't collateral crime. I mean, remember, the defendant didn't commit this crime. So it wasn't, if you're talking about Williams rule evidence, it wasn't Williams rule. It wasn't similar bad acts.
So how was the jury to understand why it was being offered?
The state's theory was that this was, the Bennett's murder, of course, was the motive. And it had to attack his credibility, his character, and put into evidence bad acts, even accuse him of another murder, in order to convince the jury that you can't believe that he would his confession would be false. I mean, that's the argument. You've got to believe his confession because look what a bad guy he is.
Or is another view, is it reasonable to view that here's the evidence and that's why the confession is true? Is that not a reasonable interpretation?
That's certainly the state's view, and they went to a great extent, making the Bennett murder a feature of the case and then accusing Widado to make that point.
But it was you do agree, I mean, if I'm reading the briefs and understanding this, it was only in the series of questions on cross-examination where this happened. Is that
The
correct?
accusation of the Bennett murder?
Right, and through no other witness and through no other statements during the trial. Is
Exactly. So they had no evidence
Okay.
to support this assertion and this tirade that they put.
what do you
before the jury.
understand the relevancy of the body, the bloody body, to be?
No idea.
Well, I'm just asking. I mean, what do you understand it to be?
Well, the state again wanted to
and why
shock.
are they incorrect?
Remember, I said we have three. Basically, what informs and guides this appeal is the fact that the state needed to attack and destroy his character, Widado's character and credibility. They needed to inflame the jurors' passions and mislead the jury. And obviously, because they couldn't follow, they were going to ignore the admonishment of this court and the trial court.
Excuse me. Was the photograph discussed, objections made to the photograph?
Yes, Judge.
And what do you understand those arguments to be?
Yes, sir. Irrelevant testimony or irrelevant evidence that, again, there was nothing that tied
And the
Widado
state
Delhal
made
to
no
the Bennett
statement,
murder.
and did the state make no statement whatsoever in response to that?
I mean, there was so much of the evidence. You know, when the defense continually objected, and it did, and maybe it missed some opportunities to object, but when it did object, the trial court told the state, continue. It basically admitted or dismissed the defense objections as interruptions.
Counsel,
State continue, state continue.
You're now in your rebuttal time.
Oh,
You
well.
may continue, but you've got a total of a little
Listen,
less than 9.5 minutes.
Issue 5 is very important in our case. There's some information that I need to please share with this court. So let me take 5 minutes now, and we'll say 5 minutes for rebuttal. Would that be all right?
You don't have that.
What do I have, sir?
Got 9 minutes.
Okay, 4 and 5. Claim 5 needs to be addressed in this forum. Testimonial hearsay was admitted during Widado's trial, and it was not harmless. Now, pre-trial, the defense filed a motion in limine to exclude statements purportedly made by Mr. McCrae to Officer Huffnagel, and the court conducted a hearing. The state asserted alternative theories to admit the hearsay, and the trial court ruled that McCrae's statements were, 1, qualified as excited utterances, number 2, that they were reliable.
You've got a limited amount of time. Let me ask a question. Why isn't your position with respect to the Crawford issue, if it was preserved, totally defeated by the Bryant decision? I think that's the name of it, the recent
I'd like to address
decision
that,
from the
Your Honor.
U.S. Supreme Court. Because we understand what you're arguing,
Thank you.
but why isn't Bryant
And I
somewhat
also want to
problematic
make
for your
an
argument?
analogy in the Lopez case. In the Bryant case.
Well, but Bryant's probably going to
Okay, but this is important. Okay. In the Bryant case, the Supreme Court decided, and you know what they decided, so I don't have to read that paragraph. The case expands that definition of ongoing emergency to include facts that prove the statement is testimony if a perpetrator is disarmed or surrenders, is apprehended, or flees with little prospect of posing a threat to the public. Here's my argument. It's very short. In this case, there was no evidence that Mr. McCrae's shooter was a threat to the public. Law enforcement on the scene did not testify that they were afraid or that Mr. McCrae was in any danger. For example, no guns were drawn. They weren't asking, where's the shooter? Objectively examining Mr. McCrae's purported statement, it was made to identify his shooter, understanding that his shooter would be caught and prosecuted. There's no evidence that Mr. McCrae was still in danger.
But the same thing happened in Bryant. I mean, there, the shooting occurred 20 minutes earlier in another location. The victim drove himself to a gas station where the police found him. So there was no danger in that case either of the shooter still being around. And when an officer asked the victim what happened and who shot him, and where the shooting had occurred, the victim told him, Rick had shot me. How is that different in this case? If anything, this case is less egregious.
Well, my reading of Bryant was that in Bryant, the victim, dying, but was able to leave the scene, and in doing so, got out of the danger. He was shot at Bryant's house, and after recognizing that name, after he knocked on the door and they had some sort of conversation. And in Bryant, there was an ongoing danger that as he left, Bryant probably saw they hadn't killed him and that maybe he was going to be coming after him. And there was discussion about where's the shooter and what's happening. This case, as well as in Lopez, it's about what happened. It's about what happened and not what was happening.
Well, the Bryant court looked at a number of factors, and the emergency, the ongoing emergency was one factor. Another factor that they look at in determining whether it's testimonial or not is the formality or informality of the questioning. And also, they looked at whether a gun was involved in a particular case. All those factors seem to be applicable in this particular case. It was an informal interrogation at the scene, trying to figure out what happened, and there was a gun involved, and they didn't know what the shooter was.
At first reading, Justice, I agree. It looks very, very similar. But then you look at, in Delhal's case, there were 5 officers who got the report, and they were pretty much the same report. 5 officers heard about this shooting. In our case, there was 1. In the Bryant case, the declarant...
What am I missing? I don't understand that distinction. 5 officers compared to with 1. Does that make a difference?
Corroborating, Justice Lewis,
Okay.
just corroboration and people who heard and this is equally important. In the Bryant case, the declarant was able to actually name the shooter. Name the shooter, say where he was at, and say what happened. In this case, the brother of the guy who shot the man who owned the business before. I mean, it's almost incredulous, although we aren't arguing whether he actually made the statement, but he doesn't know the guy, the name of the business before that he owns. He doesn't know the man who shot when he signed an affidavit.
He's wounded, and
Yeah.
if anything, that maybe adds to the idea that it was excited and
No, it was admitted as an excited utterance.
Yeah.
That's not the issue. The
So
issue
you're-
is whether it was testimonial or
There's a question of whether it was
non-testimonial.
preserved under a Crawford, but there was no Crawford, there was no Sixth Amendment objection, was there?
Yes, Judge. During the hearing, specifically the state, it was Terry Lenneman, he said this would be a violation under Crawford. Now, we're saying that it was preserved because Crawford is more specific to the confrontation law than the confrontation clause than the broader scope would be. If you would have said confrontation clause, Sixth Amendment. This is very specific by saying Crawford, so we're arguing it is preserved.
Counsel, you're now down to a total of 3 minutes.
I think the other thing about the Bryant case that is distinguished from our case is that Declarant Covington in the Bryant case did not indicate any possible motive for the shooting. I think in this case, the brother of the guy who shot the man who owned the business before, that's going to indicate some motive. And that goes to testimony character. I'll save the rest for rebuttal.
Or it sounds like identity to me. If you don't know someone's name, but you know who they are basically in the community, and that's identifying information, not necessarily motive information. But I guess reasonable people could differ.
May it please the court. Meredith Carbula, Assistant Attorney General, Counsel for the Appellee. I'd like to start with the notion that this Bennett murder became a feature of the trial. And Justice Pariente, we have to remember that this issue was raised as a claim that the trial judge abused his discretion in failing to grant a mistrial. So the standard is not harmless error, even if we assume they're error, which there's not. The standard is, did this so vitiate the trial as to...
Well, what, are we now talking about the
fair
comments from issue 1? Or let's go, give us the context for issue 2 and direct yourself to the idea that you agree the Bennett murder was coming in for motive, that the state was not trying to show, and certainly that this defendant was involved with the Bennett murder, correct?
That's correct. The state's theory was that Negus is the one who killed Mr. Bennett.
Okay. So what would be, let's just take it as just one piece of evidence, the picture of the bloody body. What is, was that introduced? Why was that introduced? And was it properly objected to? And why would that be relevant to show motive? It was relevant to show motive. Well, it was relevant to show motive because it was relevant to show the way in Mr. Bennett was killed, Richie B. It was... why, if you're not trying to show that Delhal had anything to do with the Bennett murder, but are you trying to say that victim looked like Mr. McCrae?
No,
and there's,
not at
I mean, which would be then again backdooring it?
The evidence of the Bennett murder was clearly the motive for the murder of Mr. McCrae.
I'm asking you one issue. Start with the photograph.
The photograph was one of evidence that the murder occurred. It was the state sought the death penalty or was contemplating seeking the death penalty. It was to show the murder occurred. I mean, the state needed to show.
Was he convicted by the time? Was the brother convicted?
3 years later. By the time of trial, yes, but at the time of the murder, no.
So, basically, there's no question that they were trying to say, well, maybe the brother didn't actually kill this defendant. I mean, he was convicted of it. So again, explain again why, if you aren't trying to show Delhal knew how the defendant was, how this other victim was killed, what's the purpose of showing a picture of a bloodied victim, other than to raise this issue of there being a sort of a dangerous family that kills people?
Your Honor, the photograph was just one piece of evidence to demonstrate that Richie B. was murdered by Negus Delhal. And that was one piece of evidence to demonstrate the murder happened.
Well, let me ask you this. Maybe we can put this in. Was the defense, their defendant's defense, I guess, that I didn't kill Mr. McCrae and I did not know anything about this Bennett murder? Was that the defense in this case?
Yes, Justice Quince. That was the defense. I didn't kill Mr. McCrae. I didn't know anything about the Bennett murder. The state's theory is that Widado gained information about the Bennett murder. Now, we have to remember that the Bennett murder, there was very little evidence to link Negus to the Bennett murder. There was one fingerprint found at the scene in a public place, and there was Mr. McCrae. And
was the brother in jail or the Bennett murder at the time that McCrae was killed?
Yes, Negus was in jail. In fact, the evidence was that Widado visited Negus in jail 2 days before the murder of Mr. McCrae, and that there was a docket sounding close in time to that murder. So the notion was...
I don't think they're contesting that some evidence of the Bennett murder could come in to show motive, and I think the most significant one is the affidavit of McCrae at the Arthur hearing that where he's now identifying somebody as the shooter, and then somewhere either at that time or after it, McCrae finds out that this is the sole eyewitness. So the focus is on whether McCrae, that there's only a fingerprint. Okay, so you say there's only a fingerprint, but I'm still maybe at a loss, and maybe you of where the bloody body comes in to show what Delhal, which is what you want to do, is show what Delhal knew, what was in his mind when he went to kill McCrae. And if he didn't know how, or there was an implication that he knew how the Bennett was killed, or that I just don't, and I don't understand that. And it was objected to. I guess you're agreeing it was objected to?
Yes, Mike.
Okay, and the judge said it's relevant because what?
I don't recall the judge's specific ruling on why he viewed it relevant, but one of the issues, one of the factors in this case is that it was a murder for which the state was seeking death. And Negus, during the visit on November 27th, which was 2 days before the murder, when Negus and Widado visited in jail, was the notion that Negus had committed this murder for which the state was going to seek the death penalty. And that concern about the death penalty, which I think makes
Can you help
details
us
about the Bennett
understand how
murder.
the photograph went to one of the aggravating factors in that prior murder?
Only that, it was an execution-style murder. It certainly was evidence of CCP, I think.
Well, CCP is not just the torso. It's a plan. It's calculation. It's not just showing that someone has bullet holes in them, is it?
That's one piece of evidence. You're right. It may not be a complete picture, but it's one piece of evidence. And Justice Lewis, I understand. I mean, I think Justice Sperriento, you said, all right, even if the photograph was admitted in error, it was Negus who was accused of that killing, not Widado. So there's any notion that that was prejudicial, reversible error, I think is refuted by that. When you look, the state called 18 witnesses in this case. One testified solely about the Bennett murder, and he was a fingerprint guy. Only four testified about both murders. In other words, 4 of the witnesses who were called testified about both murders, and the other 13 only testified about the McCrae murders. I think the evidence record clearly refutes any notion this was a feature of the trial. And so I think that even if the court says, well, the photograph went too far, the state had always contended that Negus was the killer. Now, that sort of dovetails into the first issue. And I think what you have in isolation of this notion, the prosecutor used you 5 times and et cetera, is this taking this comment out of context. Because the question was, did the prosecutor thereafter, after this question, which we're again reviewing for an abuse of discretion, whether a mistrial should have granted because of this one question, did the prosecutor thereafter accuse Widado of killing? And the answer is no. During closing argument, for instance, one of the first things that she said was, Negus killed Gilbert Bennett. Second, even if you look at the questions...
You say it's under an abuse of discretion, but the first time there's an objection, now the judge doesn't rule immediately because his client answers. The second time, though, he says, so someone actually cared. You didn't figure on that, did you, Mr. Delhal? He says, objection, I have a motion to make. The judge didn't, what he said was, there's no, Miss Levine's indicating my client was involved in another homicide. She never said that. I think she did. She didn't. I believe she didn't. Is that the motion? That's the motion. I'm going to have a continuing objection to anything about my client being involved in any homicide. So the judge didn't even recognize that what was being said. Now, either that's because it's like a golden rule where you is used in a way that isn't really conveying it, but it looks like it does on the
And I think
the
you hit the
page.
nail
Is
on
that
the
what
head.
you're saying?
I think you hit the nail on the head. The comment was so innocuous to the judge, he didn't even think he'd accused him of the murder. And let me tell you why. Because surrounding those questions, at page 2252 of the trial transcript, the question was, now the state's theory, the state's theory was is the Bennett murder was a drug killing, and that that was the reason why, that Conroy Turner had ripped off Negus Delhal and members of his group. And of course, the defendant during his own testimony admitted association with this group. But that was a theory. And so after she said, and so she's talking about the group, the group involved, including Negus and Widado, you couldn't find Conroy Turner, so you killed Richie B., his best friend. Right after that, and so she said, after your brother took the contract to kill him, and after your brother killed him, no. Your brother killed him right there in that auto shop that day with his shirt off, showing his tattoos, something you don't have, right? That's why they knew it was your brother and not you. So, in context, when you look at that...
What's the purpose of those questions? I mean, what was that going to... Why is he, if the implication isn't it's, then what's the relevance of that cross-examination?
The relevance of that cross-examination is...
He wasn't trying to say he killed Bennett, was he? So he goes, that's why he knew it was your brother and not you. What's that going to?
Because, again, going back to the issue of motive, the state's motive was... Now, this is also cross-examination. After the defendant has denied, has recanted his confession, saying it was all a lie, he knows nothing about nothing.
Let me ask you this. I mean, is this a seasoned prosecutor? Does she try a lot of cases, homicide cases?
This is a Miami-Dade prosecutor, but so I don't have personal knowledge of that, but I think that she is an experienced prosecutor.
Because I got to tell you, I mean, in looking at the, for example, moving forward a little bit, and looking at transcript in the penalty phase, she actually begins to argue that I ask you to, in closing argument, I ask you to think about whether the mitigation that's being presented to you are excuses, sustained. 2 seconds later. It's not about excuses. I suggest to you, I really think it's one thing. Stretch it out, may make it more, but it's an excuse. Once again, she completely ignored the court's... It doesn't stop there. I got some more. Then later on, he tells the jury, you follow the law, you said you can do it, he is dangerous. Objection. I have a motion. Okay, says the judge. I have a motion. The court, the objection is sustained. Go ahead, please. Then the prosecutor. His previous crimes of violence shows he's dangerous. Completely ignored the judge's ruling. Then he goes on. Here's the judge. You keep saying the word. Don't do that, please. I have a motion, says defense counsel. The court, please don't do it. Go ahead. Next thing. His violence speaks for itself. It just seems to me like it's a free-for-all. I mean, we're going to ignore judges' rulings and just say whatever we want to say. Should we have to go to the bar with this? What do we have to do here?
I understand your point, Justice Labarga, but again, I would ask you to take a look at the entire context of the closing argument. I think if you look at it...
we keep doing that in case after case after case, and I don't mean to take it out on you. You're the messenger, and you're doing the best you can with what you got. But it seems to me that in a lot of these homicide cases, prosecutors keep doing this, and I guess the belief is the evidence is so strong, they're just going to hold it to be harmless error or whatever, and we get away with this. But it keeps happening, and we keep mentioning in opinion after opinion, stop doing this. And yet it keeps happening. So what is it that this court needs to do to stop this?
Your Honor, I think the court has done well to explain what the parameters of closing argument were, and and I don't think that if it had been me, perhaps I've said everything the prosecutor said. But I think if you look in context, I mean, the prior violent felony is an aggravator, and he had 2 prior violent felonies convictions, And I think there's an escalation of violence. And I think if you look in context, the prosecutor's argument was centered on two things. The fact that there was an escalating violence, and he had been put on probation twice and still was violating the law, including up into killing Mr. McCrae. And in context, that's what she was talking about. Also in context, she was talking about that the jury should not put great weight or put little weight at all on the mitigation, because the only mitigation in this case was essentially there was no mental illness, no brain damage, no mental mitigation whatsoever put on. The only evidence is that his parents were drug dealers. At age 18, his mother, who testified that she hid her vocation from her children, at 18, she went to jail for drug dealing and then was deported, and that he assumed responsibility for his brothers.
And by the way, I don't mean to take it out on you. You're a good lawyer, and I always enjoy your arguments. And I know you're the messenger here, so I don't mean to shoot you. But I just read these transcripts, and my staff and I read these transcripts, and it seems to be occurring over and over again, and needlessly. And then you have to stand here and argue those things. But it just seems to me that we're past the stage of asking and instructing lawyers not to do this. And there ought to be something we can do, maybe start filing grievances with the bar.
Well, all I would say, Your Honor, is when you look at it in context, is that this defendant does not deserve a new penalty phase because of that argument. So if you want to talk about how the prosecution shouldn't make these arguments, I mean, she didn't make the same mercy argument, you must recommend death, and we don't seek the death penalty in every case. So what I'm saying is, Your Honor, is in this case, this should not warrant a new penalty phase when you look at it in context.
How about Brooks? Brooks was sort of the culmination of several arguments happened to come out of the same office. And they tended to address mitigation the same way over and over and over until it hit Brooks. And this court laid out some parameters. Why does this argument not violate the parameters that this court established in Brooks? Because
the prosecutor did not make the specific arguments that you condemned in Brooks and Urban and its progeny, and while the prosecutor's argument may have had an emotional flow, in context she was discussing a specific aggravator, the violent felony aggravator, and how his violence has escalated, and also the fact she was arguing that the jury should give little weight to his mitigation because, in fact, it was almost non-existent.
Didn't use those words.
She talked about...
Those were not the words. Yeah, I mean, you have to agree with that, as they've been talking about.
I don't dispute.
Excuses, and it seems to me, as that's what this court has said, that in discussing mitigation, then it needs to be discussed on the legal basis, not on something that's emotional and denigrating what we and U.S. Supreme Court have said, that you can put this evidence on, and if you don't consider it, it's reversible error. So that's what sort of
again I would
creates a problem.
I would ask this court to again put it in context, because when she was discussing the lawfully admitted aggravators and the fact, and the prosecutor is authorized, of course, to argue that the jury should put little weight on mitigation. And I'm not saying that
the problem becomes, on the one hand, we've always said that future dangerousness is not an aggravator, right? But what she does is she uses his prior record and this crime to really, and when you dig deep into it, and she actually uses the term dangerous, doesn't she?
Certainly,
and so I can understand the defense argument that she is putting this all together and saying this is a really dangerous person, and therefore don't even look at this mitigation evidence because we need to put him away because he's just a dangerous person.
She did not tell the jury to ignore the mitigation evidence, but again, future dangerousness is clearly not relevant, and it's not permissible. She did not argue that the jury, you should put him to death because he gets into prison, he's just going to kill people.
She may not have, you don't have to always use the exact words okay, forget that, and let's put him, let's give him the death penalty, but because he, you know, he's going to commit crimes in the future. But the way she phrased this is, in my estimation, very problematic.
Well, you know, I think that the question is the impact on the jury. You know, when she talked about he's dangerous, what it was a discussion of in context was the fact that he had been put on probation and given opportunities, and he had just escalated his violence. And so, you know, I think this logical. That's why prior violent felony is an aggravator.
How about, though, and I think that when Justice Labarga asked you about this prosecutor, doesn't this, though, dovetail into several things that this prosecutor actually did, including the fact that when the defendant had taken the stand and said, no, he was not present at the time of the Arthur hearing, he was in jail, the judge, the prosecutor said, can you prove it? Well, obviously the prosecutor knows whether someone's in jail or not. They knew, and he goes, yeah, I can prove it. Here it is, that this prosecutor, that the judge doesn't do a proper Richardson hearing. The judge says that it was not disclosed, but they didn't talk about whether it was willful and whether there was substantial prejudice. But now we have a defendant who says, I was in jail, and the prosecutor's not even allowing him to be able to verify that. So he's sort of showing the jury this guy isn't being truthful in what he's saying. Then you have, again, this idea that why is that other bloody body coming into evidence? I'm assuming the McCrae body came into evidence.
Certainly.
And so now you have the image in this jury's mind of his brother and that murder, and it's sort of out there. And then you have the implication in issue 1 that you all killed this guy. You didn't count on there being a witness. All in this, and they carry that into the penalty phase where he's talking about where she's talking about what a dangerous guy there is. That's what we've got. I mean, and you would agree, we got to look at, if there's errors, we've got to look at them cumulatively to see if there are errors and they were preserved, whether it's harmless beyond a reasonable doubt. And it may have been harmless beyond a reasonable doubt for the guilt phase, but then the question is, do we carry that over and look at whether cumulatively those errors were harmless beyond a reasonable doubt for the penalty phase, leaving the jury with the impression, well, he committed this murder, he was doing it to help his brother, but you know what, he was probably involved in that other murder anyway, because he's a dangerous kind of guy.
Well, okay, let me try to take each of those things separately. All right, first of all, on the booking report. Now, I think it's not, the record doesn't support the notion the prosecutor says, can you prove it? I don't think that's what the defendant said. He had records supporting that he was in jail, and you have those with you today, etc. Now, first of all, the record at issue was apparently just some sort of booking report. It had no certification of the custodian. It had no seal. It was disclosed at the last minute, and the defense counsel admitted that he failed to disclose it. So I don't really think the issue of willfulness is there. He said that, you know, his argument was, well, number one, it could be, you know, I can use it to refresh his memory, and the judge says you don't need to do that. And there were other arguments, but he admitted he didn't disclose it. So the fact is that this had been one of several times when the defense had been a late disclosure. The document was unauthenticated. There was no, you know, the defense response to that and to the judge's inquiry was, well, I'll just want a continuance so I can subpoena the custodian. Well, the custodian was unidentified, and the trial was due to end the next day, and the judge was going to be unavailable. So
Well, the Richardson rule requires, basically says that exclusion is the last possible alternative.
I agree with you.
I'm reading the record here, and we read it very carefully. The judge did not explore any other means to mitigate the prejudice the state claim it had.
I disagree, Judge LaVarga, because here's what happened. First of all, the court did inquire into the prejudice, at least the prosecutor volunteered. Had I known that they had these records, I wouldn't have asked the question about the records. So I think it was established procedural prejudice. The only remedy the defense asked for was a continuance to subpoena an unidentified records custodian to get them into evidence. That was the only remedy they asked for. And then thereafter, if I could just...
Okay, sure, I'm sorry. I was
Justice
just
LaVarga,
going back
then
to what the state
thereafter,
had said.
the judge allowed the defense counsel on redirect to show him the booking, Widado, the booking report, and say, isn't this the document that I showed you to refresh your memory about how you were in jail? Yes, it was. So the jury saw this piece of paper. They didn't read it. They saw him hand the paper to the defendant and say, isn't this the booking report, or isn't this the document that I showed you to refresh your memory that indeed you were in jail during the Arthur hearing? And so the judge allowed that, and I think that's probably why he did allow that. Also, the fact is, the state's theory was not that he was at the Arthur hearing. The state's theory was that the day after the Arthur hearing, he met with Paul Gerson, who was Negus's defense counsel, and received information from Mr. Gerson and or someone present at the Arthur hearing that Mr. McCrae was the witness. And in fact, that's what Widado said during his confession.
All right, let me go back to the cross-examination by the prosecutor. Asked Widado if he had proof with him that day that he was incarcerated on September 6th. So if the state was making this the big deal, when he then said, yes, he has the proof, then the prosecutor's objecting to it. The judge asked the prosecutor if she disputes the fact. If it's, again, this is a prosecutor, we're the state trying to seek justice, not to win every point. And so my question about it really went in the broader context of what this prosecutor was trying to do regarding Widado, both in the guilt phase and in the penalty phase. And sometimes things are done, and you look at them all cumulatively, and you say, you're trying to make this guy out to be a liar, you're trying to imply that he was involved in this other murder, and now you're going to dovetail that in to the penalty phase, because certainly the guilt, there's certainly a way enough for the guilt phase. As far as the penalty phase, it's, it's certainly proportionate with the judge, with the aggravators, but the question was the jury going to give the death penalty? And it was an 8-4. 8-4. So it's not like it's, again, it's not a huge vote for death, and so that's why you look at this and say, well, could these things have had an effect on the jury in recommending death rather than life?
Well, I think the argument about this booking report is that the error is that it undermined Delhal's credibility, because allegedly his credibility is on the line because of his confession. But the thing is that if that's the error, that it undermined his credibility, and this was a he said, she said, he made the confession, no, I didn't, and whatever confession I made was false. The thing that got Mr. Delhal was two guns. Mr. Delhal was the first person to tell the police that he used 2 guns. The guns, the police found 11 shell casings at the scene. Well, of course, we know shell casings are only coming out of an automatic. Widado told the police that he used 2 guns, a .38 and a 9mm. And ballistics, which were examined after the first of the year, the report came back that there were 2 guns used because there were 2 different kinds of bullet fragments found at the scene. Nobody knew that. That is what caught Widado. And so any notion that there was a shot at his credibility being believed by the jury, 2 bullets.
I guess that's what makes this whole thing so sad and dovetails into what Justice LaVarga is saying, is that you have a confession and you have the bullets, and then you sort of wonder what else the prosecution was doing with other evidence that became somewhat, at least for this appeal, to be either the sideshow or being used for some other purpose. So I agree with you, there's, the guilt's there. Certainly no one's making a argument that he should be acquitted of this murder, but the concern is whether he got a fair trial, and I think that's what we've been talking about this morning.
Well, again, I would say, you know, when you, any notion that the Bennett murder was a feature of the trial, I think is absolutely refuted by the fact that out of the 18 witnesses, only one testified only about the Bennett murder, and 4 testified about both, and 13 testified only about the McCrae murder. And I think this court has adequately recognized that the Bryant case controls the issue of the dying declaration. And unlike Lopez, where the perpetrator was still at the scene and the gun was secured, just like in Bryant, the perpetrator was at large, there was a gun, the victim was grievously wounded with 15 gunshots to his body, was discovered by the medical examiner, and the concern was to get the shooter to protect. And in fact, also, even another distinguisher, if I could just finish my sentence, is that the area, I mean, Widado had come back and shot twice. He shot once before he got in the car, and then after he got in the car, according to Widado, to make the witnesses duck. So I think the Bryant case clearly controls the issue, because they're admitting that it was properly admitted as a excited utterance. In fact, I think that it would have been properly admitted as a dying declaration, but that the Crawford issue is governed now by the Bryant case. So we would ask you that this court, when reviewing the record as a whole, affirm the conviction and sentence to death.
If I may just address a couple of issues. In Claim 10, summarized claim that the state presented more than 30 non-statutory aggravators. They mentioned dangerous 16 times. The brief
Mentioned
cite the
dangerous how
cases
many
that support our argument. 16? But what I want to say to you is this. The state literally scared this jury to death. And the reason I'm saying is because this brief does not address, you can't hear the horrific impact that the prosecutor had on Widado's jury. The record cannot reflect how terrified the jury must have been and how they felt as the prosecutor repeatedly screamed out warnings that Widado was dangerous, that he will be dangerous, and that he could not be fixed in his entire family.
When you use those kinds of terms, are you talking literally, or is this a reading of the record?
I was there.
Was the prosecutor actually screaming?
Screaming.
So you're
Maybe
talking
someday
literally.
you'll get the videotapes of these, and you'll see how unbelievable some of these arguments come out. But
Are the
you've seen them.
videotapes in evidence? I mean, are the videotapes part of this record?
I don't even know if there are videotapes.
Oh, I thought
I'm just
you
saying
said-
someday maybe this court will have videotapes to look
Well,
at
we
as
can't
well as
then, I
transcripts.
mean, since there's no objection, she's screaming, we can't take that into account.
Okay.
You know that.
What I need what this panel needs to hear is that the state literally scared Widado's jury to death by urging jurors to imagine how he's going to affect other people. Record 139, the transcript 560, this clearly goes to future dangerousness. And these errors are not harmless. If I could, my time is up. I want to thank this panel today for allowing me to present this argument. We request that Mr. Delhal's convictions be reversed and that he be granted a new trial, or in the alternative, remand this case for a new sentencing hearing. Thank you.
All right, we thank both of you for your arguments. The court will now take a 10-minute recess. All right.
Court of Law is now in session. Please be seated.
The next case on our docket is Haney versus the state of Florida.
Good morning. May it please the court. My name is George Burton. I'm here on behalf of Justin Haney. He has been convicted of 3 counts of first-degree murder and sentenced to death for the murder of Ivory Hamilton. I'd like to address the 3 murders as they were argued by the defense counsel at trial and how he characterized them. He characterized the murder of Mr. Hamilton as happening in the course of mutual combat and therefore should not have been a first-degree murder case, but a lesser murder. He then characterized the murder of Miss Bukowski as sort of a self-defense because he did it in panic when she bobbed from under the bed and there were handguns down there, and so he shot her in sort of a panic and in defense. And in the shooting of Ivory Hamilton, that was characterized by the defense as an accident. He never purposely shot her, and as a result should be no criminal liability whatsoever. That was the argument that he made from the evidence that was presented. And there could be inferences that could support that, but the judge didn't agree, and neither did the jury. And the reason why those things could be argued that way was the kind of evidence that was presented in this case. The evidence was the confession of Mr. Haney himself. It was the testimony of the first responders, and it was the testimony of the next-door neighbor. There was no forensic evidence of any kind. There was no where the bullets came from, what angle, because the people, the parents that were murdered in this case were both alive when first responders came and were removed.
But let me just make sure we understand. There is no question in this case that Mr. Haney killed these 3 people. Actually did the shooting. There's no question that this was someone else. He was the one who actually did the shooting, whether we want to term it accidental or response to something. That is the state of this record, isn't it?
No question. By his confession and the fact that the murder weapon was last in his possession, I think it's overwhelming that he did these shootings. And now getting back to it,
So are you going to argue? You said that's the way this was presented. Is
Correct.
that the arguments that you're making too? That that's the sequence of this murder? Are you arguing that the death of this child was totally an accident and that Mr. Haney is not responsible for murder of that child?
No, but I think the sentencing order is not correct, and I'll explain that.
Okay.
Maybe it would be helpful, at least for me, is if you can address. You were starting to tell us what the defense theory was, but what are you going to argue? All your points. Which argument are you going to start with?
I'm going to argue EHAC, but I want to first set an explanation for why EHAC doesn't apply and why the sentencing order is not correct. And you got to have to get fact intensive to do that.
I guess what I would say, let's just, even if you take HAC aside, got a murder of a child under 12 and you got 2 other murders, it seems to be a proportionate death sentence with the fact of 2 murders and the murder of a child. I don't know how you get around that that's not a proportionate sentence, with or without whether the child knew his parents were being killed or not. It just doesn't seem to me to be, he kills 3 people and 1 is a child. I mean, that's got to count for, in our death penalty jurisprudence, that killing multiple people in one incident is a significant, puts significance on the prior violent felony, in this case, the contemporaneous aggravators.
Well, it does, but you have to go with the hand you're dealt, and that's the sentencing order that the judge, the findings he made. And I want to address those and explain why they're not accurate. And this is the way. The shooting sequence and how it happened, there are multiple times that Mr. Haney described what happened under questioning by police. He spent the great bulk of his confession time denying any involvement. And then when they came back to the room with the murder weapon and confronted him with that, said, they got me, and he confessed. First, his confession was, I don't remember much. I shot Mr. Hamilton. We were arguing. Mr. Hamilton had a gun, and I pushed him on the bed. The gun fell, and then shots started going out. That was the initial version of how things happened. The police kept pressing, and rightfully so, because there were a lot of gaps that were not filled in how this happened. Remember, there's no eyewitnesses. Ms. Bukowski was coherent in speaking when she was found, but she had no recollection of what had happened, so she couldn't tell the police what happened.
So it's his version that another version of the defendants, that the victim, the male victim, had actually put his gun down. Don't we have that in the record?
Well, the gun is down on the ground in a jammed state, and it is consistent with what he said, where he pushed him on the bed as a part of their fight, and he said the gun fell to the ground that Mr. Hamilton had. That is a recurring statement in his confession. That has never wavered. That's pretty consistent all throughout. What is not consistent, and what is very, very difficult to discern from this confession, is who was shot next, Ivory Hamilton or Miss Bukowski. Now,
and why is it important which one was shot?
Because if it happened the way I believe the Mr. Haney described it, is after he shot Mr. Hamilton, and he said he thought he shot him in the chest. He didn't even realize he shot him in the head. He said, I thought I shot him in the chest. He went down the bed, and he had the gun, and child came in and the mother came into the room just because of the sound of the gunfire. Now, he said he turned to fire, and he made a shot, and both went down. Now, of course, that didn't happen. Both did not go down. But what did happen was Ivory Hamilton went down because she was shot, and Mrs. Bukowski went down under the bed to hide.
So, how do you explain how she was hit on the head prior to that?
She was actually shot in the arm, and through the arm into the head.
There was a blow to the head, not a shot.
Of the child.
He was
The
slapped
child,
in the face, right?
the state argued, and that was the linchpin of their case, that the medical examiner's testimony that this child was slapped within minutes or up to 4 hours before this happened. And there's no explanation for how it happened from anyone. So the way that the linchpin of getting this to be the murder of this child, as they did, is that, well, he slapped the child, and then he purposely went and shot the child. That is their theory, but there's no evidence to support it, other than the medical examiner saying...
Wasn't there testimony that the child was tugging at his pants after he shot the father?
Yes. That in one of the alliterations of this explanations, that's what he said. But towards the end of the confession, when the officers were trying to get him to admit or deny whether or not this was witness elimination, they've gone through it several times. Now, weren't you afraid that Miss Bukowski or the child would tell on you? He said, well, I got worried after I hit Cleveland. It says Cleveland in the record, and you don't know if that's Miss Bukowski or the child. I assume it's the child because he talks about the child in the next statement, and says he got worried at that time because he had shot her. Hitting means he shot her, I believe, is what he meant. And then now he shot the two of them, and he has the mother down below hiding, and Bob's up, and he shoots her. And I think that's the problematic murder in this case, not the one of the child, but of the mother. Because she was the one that came in screaming, and when he shot the child, she dived down in the bed for cover. Because when he said he shot that way, they both went down simultaneously.
How far was he when he shot at the two of them?
From the scientific evidence, the shot to the child was at close range. The one for the child was close range. It was because they were stippling on the child.
Right, so doesn't that contradict what you're saying, that he shot at both the mom and the daughter and just happened to hit the daughter first?
He said that he shot in that direction in a panic, and they both went down.
How far away?
The child was close to the mother as she was found, and it would have been,
How far was he from them?
it had to be less than 5 feet.
Well, isn't that contradictory to saying that the child was killed at virtually point-blank range, less than 2 feet?
Well, he said he did it while, after the tussle with Mr. Hamilton, he said, I'm getting out of here. And the child tucking at him and going over to the mother, and boom, shoots the child. The mother goes down under the bed. He says, and this is what he explains later, because the police are trying to put this together. He said, well, I think she had access to guns down there, and when she bobbed back up again, I shot her.
I mean, you're saying, and I'm trying to understand, I mean, your point would be that if the child shot before the mother, then Judge Eaton's sentencing order that says that the child saw both her mother and father killed and heard her mother screaming, or would have heard her mother screaming, would be incorrect.
That's right.
Now, in terms of this, though, let's just go to what happened with this child, who's a helpless child, 6 years old.
5 years old.
Knows the defendant because he lived in the house. And the child, what comes in while he's arguing with the father, and the child is undeniably present when he sees and sees the defendant kill her father?
The evidence is not clear on that. According to his testimony, she left the room. The father sent her out of the room.
But she comes, so when's the tugging on the shorts that Justice Quince was mentioning?
After he shot the father.
Well, if she's tugging on the shorts at that time, presumably she's in the room at the time that the defendant shot the father. Now, the question I had was, with the mother, are you saying, I'm assuming, this is a bed, right? What size is the bedroom?
It's no more than 10 by 14.
Okay, so it's a small bedroom. What size bed is it?
I believe it was at least a queen size.
Okay, so was the mother on the same side of the bed as the defendant was? Because when you say duck down, it sounded to me like she must have been ducking behind the other side of the bed.
He was asked several times to draw where he was at several increments of how this occurred. Now, if you take what he said, and it's very confusing, he was on the other side, the opposite side, by the dresser when he shot the daughter and the mother, who were together by the other side of the bed. And the daughter...
But that's, okay, so that's where we go back to what Justice Polston says, is that's not possible, because if they're separated by a queen-size bed, that's not being shot within 2 feet. So we don't just accept what he says about how this took place. He's within close range of a child who is tugging on his shorts, and I'm having the impression that what happens is he turns around and he shoots this child in the head.
I think that's a fair inference.
Okay, so how much work, I mean, in terms of this as a murder case, a death penalty case, because that's what we're talking about, whether the child heard the mother screaming part of the time or not, to me, this is a horrible murder. He kills a mother, father, and a child. Again, I'm not sure what else I need to know to say over a nothing. I mean, over a argument about drugs. I mean, no real motivation.
Respect. That he was disrespected.
Out of disrespect, because he was disrespected, even worse. So I don't see that, to me, now it may matter to some other people, because I'm not a big fan of these HACs that happen instantaneously, but even if you eliminate HAC, I think this is still a death penalty case. And so let's just assume that you're correct, that the evidence is unclear whether the mother is shot before the child or not, but the mother must have been screaming draw the attention to the defendant. And so again, the child at least hears the screaming. What makes this, how is this not a proportionate death sentence?
Well, because in the mitigation development of this case, Judge Eaton accepted everything that was presented. He accepted that there was a 4-day cocaine binge. He accepted that Mr. Haney had at least 10 beers that day. He smoked marijuana. It's right in his sentencing order. He accepted all those things. He accepted the testimony that this person was emotionally disturbed. Now, it wasn't clear as to why. I'll call him Expert R because I can't pronounce his name.
Can we go back to the drugs and alcohol?
Yeah.
The judge said that he'll accept that there was some testimony that he had been drinking, but then he says he shot them with deadly accuracy, and then what he did right after, how he purposefully concealed the weapon, his clothes, the drugs. He says if the defendant was under the influence of alcohol or drugs, he was not affected at that point of being significantly impaired. So it's not quite accurate to say that he was on some kind of cocaine binge that made him not able to even form an intent. That's not what the judge found.
But this wasn't an Ozzie and Harriet household. This was a drug house. There were weapons everywhere. There was a cocked handgun on the coffee table in the room, cocked and loaded, with a 5-year-old walking around.
I thought you were saying why there's significant mitigation. I'm going on, even people that live in a drug house, we impose the death sentence or uphold it if they kill people in the course of it, right?
But Mr. Haney...
There's lawlessness and then there's lawlessness.
Right.
So
but
I still don't understand how that goes to that mitigation outweighs the aggravation if there's no evidence that he is on a cocaine binge, and that's what is going on with him at the time of this murder and right after.
Well, the defense proved or put adequate evidence that there were 2 statutory mental mitigators here. And the evidence was twofold. It was either he's either emotionally disturbed or he has brain damage, one or the other. And Dr. R kind of thought it was that he had impulse control problems that were from childhood. Mr. Hine was suspended from kindergarten for behavior. He went to jail as a juvenile and attempted suicide several times in prison. This man wasn't right. There's no question about that.
And that evidence was presented?
Yes, it was.
Okay, and they listened to that evidence?
That's correct.
Both the jury and the judge?
Yes.
And evaluated it?
Yes. They did, and the judge, although not finding it statutory mental mitigation because the state never rebutted it in any way, they accepted it as true as well, but for the police testimony that the judge didn't accept in his sentencing order. So it's when you have evidence of mental mitigation like that, you have to accept it. So that makes it more mitigated.
But the fact that he has, I mean, we see cases all the time where we have accepted and the judge has included in his sentencing order that the defendant has mental problems. But we also have, in some of those very same cases, there's evidence that indicates that despite mental problems, despite people having consumed alcohol or having consumed drugs, that the circumstances demonstrate that the defendant knew what he was doing. This defendant, after he has his altercation with the male victim, goes out and gets another gun, comes back to continue the argument we're not exactly sure why, but the victim doesn't have his gun any longer. The defendant shoots him and really from what the evidence indicates, he's on the other side of the bed. These other people come into the room after they've heard this gunshot, and he, deliberately shoots them. I just don't understand how that doesn't demonstrate that despite any kind of use of substances or any mental illness, or mental problems, I should say, that this defendant did not know what he was doing and that these are not first-degree murder cases.
This wasn't an issue of competency. It's not an issue of competency, and we concede it's not an issue of competency. What's
What
an
is
issue
the
of,
issue of what?
he is mentally ill to the point of having poor impulse control. When he gets angry,
We see those a lot.
well, it's mitigation, Justice Quince.
And you know what?
And he found this as mitigation. The problem is, it doesn't negate those factors that indicate he knew what he was doing and that this was a terribly aggravated case.
It's not a question of whether he knew what he was doing. Is could he conform his conduct to the requirements of law? No, he's emotionally ill. And why, I don't know.
He conformed his conduct to call his ex-girlfriend to go away to buy new clothes, the same clothes that he had, and wash the new clothes to make them look like they were old. And I mean, he had the ability to determine how to get away from these unlawful acts, but you're saying he didn't have the control not to commit them.
If you recall the end of the confession, after he put up his hand and he swore he was telling the truth to this officer of everything that happened, and he was going away for life in his mind. He messed up. He refrained. I was doing so good. I have a serious problem, but I was doing so good, and I hope now finally I can get help for it. And this is because this was the life that he led.
But here is the issue. You have a judge, Judge Eaton, who we have many cases where on appeal the issue is the judge doesn't weigh properly the mental health mitigation because they look at it as competency. No, this judge didn't do it. In fact, as respects the murder of Sarah Bukowski, where there was a vote for death penalty of 8-4, let's not forget the judge overrode that recommendation and imposed life because he found that there was significant mental health mitigation. So he followed the jury's recommendation as to the first murder. He overrode the death penalty recommendation as to the second, but when it came to a helpless child, as Judge Eaton said, the murder of Ivory Hamilton is another matter. And because in this state, any state that has the death penalty, what we recognize is that children, especially children under the age of 12, are especially vulnerable. And he killed at point-blank range a helpless child who had most likely just seen her parents murdered. And so at some point, what Judge Eaton said in weighing this, and it's a difficult task because life and death is at stake, he said, no, that was one murder in this case too many. When you turned your gun on a 5-year-old child, whatever mitigation that you had, it doesn't outweigh this aggravation of the other two murders and the age of the child, and he found the HAC, and that's what we're talking about here. So we're not disputing significant mitigation, but we're saying whether Judge Eaton, whether he erred in saying the aggravation outweighed the mitigation, and then I'm asking you, how is it not proportionate? So so tell me the case that says when someone's murdered 3 people and the person whose the death penalty is being imposed is a 5-year-old child, even with mitigation like this, that the death penalty is not a proportionate penalty.
Well, in this case, had Judge Eaton not found EHAC, he would have done the same thing for the murder of the mother.
We don't really know that, do we? And so would you say that...
If you read his sentencing order, that is a fair inference from what he said. That's what separated...
I guess I'm asking you about proportionality, assuming both... even without EHAC, and I'm asking you, is it a proportionate sentence? That's different than if we found that HAC was erroneously found and whether it was harmless error in terms of the sentencing recommendation of the judge.
It's a difficult question, and I will say this court, especially in the last few years, has given a lot more weight to prior violent felonies, which is what you're asking. Isn't the prior violent felony involved here enough? And arguably it could be. It really could be. But before you make that judgment, he should be sentenced properly. And you may conclude after a resentencing that you know what? The prior violent felony is sufficient.
And we should have a resentencing here because of what exactly?
The improper finding of EHAC. That tainted the jury, for sure, that they were even instructed on that, because it didn't apply. If you read that confession, and I've read it several times to try to make sense of it, I believe the little girl was killed second. She was killed second, and the mother third. And it was done reflexively after being pulled on the leg. And
so if that were the case, and the fact that she was there and saw the father being killed, or was she not there when the father was
according to his confession, she was not there. She left the room.
But she saw him with a gun in his hand and the father on the bed shot.
According to the sentencing order, she heard the gunfire.
Okay, but she came in the room, saw the father on the bed shot, saw the defendant with the gun in his hand. She runs over to him and starts pulling on him. And so that scenario is not enough for heinous, atrocious, and cruel. Is that what you're saying?
Yes, that's what I'm saying.
Well, isn't that contrary to our jurisprudence? Don't we have a case where there are two sisters, I believe it's Brooks, and both of them are murdered, and that was the argument that...
Francis, that's Francis.
I'm sorry. And that was the argument because we didn't know, when, because nobody survived. Yet it had to be that one was killed while the other one watched, and it was the serrated knives from the kitchen, as I recall. And this court, I believe in that case, held that HAC would be applicable because you're watching your loved one be executed by the perpetrator of this. Is that not the fact?
If there was a significant time between the murder of Mr. Hamilton and the murder of Ivory Hamilton, I would concede that EHAC is sufficient, is proven here, because to have her in horror and contemplating the death of her father, that would be EHAC under Francis.
So you're arguing then the distinguishing factor is the timing, and that this is
correct,
virtually simultaneous, and that's what you're arguing with that?
Yes. Well,
do we have evidence, really, of that?
Yes.
It's simultaneous, and that's through?
The evidence, testimony of Michelle Collin, the next door neighbor. She said there was 3 to 6 shots in rapid succession.
I mean, I guess, and this will be for Mr. Nunnally, it's really up to the state to prove by clear and convincing evidence which murder occurred first, second, third, and whether there was sufficient time. And are you saying there's nothing in the record?
Yeah, because he never really ever even admits to shooting this child, really. But when he finally gets to it where the gun is that way, he says they both went down at the same time. That's what he remembered. That means she dove for cover and the child was shot.
You are now down to less than 2.5 minutes total.
Thank you.
May it please the court, I'm Ken Nunnally. I represent the state of Florida in this proceeding. Perhaps the better way to handle this particular case is to ask if the court has any particular questions.
Well, I would ask on the HAC, what is the clear and convincing evidence that shows that the child, before she was shot, either witnessed the murder of her mother and her father, heard her mother screaming, all of that? Because it's not, we can't rely on speculation. Is the evidence that, as opposed to this being a pretty well of a rapid succession shooting?
Let's start with the next door neighbor and deal with her first. She said she heard 3 to 6 pops. The inference being those were gunshots. However, there was also testimony there was roofing work going on in the neighborhood that were using a nail gun. We don't know for sure if what she heard was gunshots or not. Now,
did the state put her on?
Yes, ma'am.
To show what?
I'm not sure why they put her on. Other than, well, actually I am, because she was the one that went over and found the bodies, or found the crime scene and called law enforcement.
But they didn't rely on the testimony about how many gunshot wounds, gunshots how many shots were fired?
No, because we had the MEs for that. The medical examiner testimony was, the medical testimony and the firearm tool mark examination testimony was 3 gunshots. One,
Okay, so we have, we know
Yeah.
3 gunshots.
One
All that
gunshot.
were fired, are you saying?
ma'am?
That there were only 3 shots fired total?
The best evidence is yes, there were 3 shots that hit. If there was a 4th shot, we don't know it, we can't prove it. We know that the male victim, Mr. Hamilton, was shot in the left temple. I believe that one was a through and through, exiting the right temple. Sarah Bukowski, the adult female victim, was shot in the back of the head. The testimony was from the medical examiner that that projectile passed through her arm, I think the tricep of her arm, and entered her head. Apparently she had her arm over her head trying to protect herself.
And how far away was that shot?
More than 2 feet is the best the medical
More than
examiner
2
can
feet.
do. Yes, ma'am. But apparently centered in the back of the head. The child now was shot also, I believe, left temple to right, left to right, entry wound, left temple, at a range of less than 2 feet because there was powder stippling found around the entry wound.
And so my question would be then, what is the evidence of, we know the father was shot first, that the mother was shot second, and that there was enough time between that where Ivory was in the room, what she would have witnessed before she killed? What's the evidence on that?
The evidence is largely from the defendant's statement as to that sequence. And the reason for that is because, as Mr. Burton said, we had 2 live victims when the first responders got there. The 2 adult victims were still alive. The child was already dead. Now, the defendant says, and there's no dispute, that Benjamin Hamilton is shot first. There's no dispute about that. The defendant says...
Let's just stop right there. So at that point, where was the 2 female victims? At the point when the male victim was shot, where were the other 2 people? What does the evidence indicate?
This is where... Okay, I'm going to answer it, I promise, but this is where you get some divergence between what the defendant told law enforcement and what he told his own mental health expert. The evidence is the 2 females are in the house when this happens, when the first shot is fired. The evidence is the child enters the bedroom and is tugging on the defendant's short pants, looking up at him in panic, and then she is shot in the head at point blank range. The inference from the known evidence that is undisputed is that the defendant slapped her in the face and shot her. The logical...
And the mother is where at this point?
Ma'am?
And the mother is where?
Okay. The reason I did it this way is because it doesn't really make all that much difference where the mother was ultimately. But the indication is, and again, we don't have a pristine crime scene because of the circumstances of, 2 living victims at the time. All of the evidence suggests, from the statements, from the way things kind of played out, the way the bodies were positioned, that the mother was already in the room and that the child saw both victims shot. Now, if you want to back off, if you don't...
Wait, but I guess what evidence are you're saying it comes from his own confession that that's what happened? We're trying to figure out, the state has to prove by clear and convincing evidence the aggravator of HAC. Now, I heard you say it doesn't matter. Are you saying it doesn't matter if the child is shot before the mother? Is that what you were, for HAC?
Yes, ma'am, because seeing her father shot is enough for HAC. The defendant's statements and descriptions of the sequence of events indicates that the child is the last victim shot. The circumstances or the way this room is, and it's 12 by 13 feet was the testimony. I think that's maybe the size of one of the rugs in the lawyer's lounge. with a bed and some other furniture, a safe, some other things in there, a couple bales of marijuana too, I believe. But this is a very cramped area, and the defendant's description, coupled up with the photographs, best we know what happened, it is that the child is the last victim killed. Now, the defendant wants to kind of go with this notion of the child was sent back out of the room. And if you buy into that position, then you've got to
I thought
look.
his argument was that was during the argument portion, when the defendant and the male victim were arguing that the child was sent out of the room. That was before the actual shooting took place and before the defendant went out and procured another gun. That's the way I understood
Well, the
that.
defendant had his own gun. The defendant had his own weapon. It was a Taurus .38 caliber revolver.
But I thought he left the scene of the argument to procure that weapon.
That was before the child entered.
That's before the child got there. He had the gun back in the bedroom with the male victim before the child got there. It doesn't matter anything else around that. But if you accept the defendant's argument that the child was sent back out and, we don't really know when she came back in and all this, then that plays into what the defendant told Dr. Reebsame, which is not in the sentencing order, but is that according to what he told Dr. Reebsame, after he shot the male victim, he went out and got the two female victims and herded them back in the bedroom and killed them. That's what he told Dr. Reebsame happened, and I don't think the defendant wants to go down that road of buying into that, or accepting that version is true.
Now, you're saying the circumstance, we got the size of the room. So what you're saying is from where the body of the female was located when the first responders arrived, that it was such that she would have had to have walked over the baby or the child to get in that position, if that is to be accepted, because
Yes, sir.
because the female victim was located in such a position that it's just not logical that she would have stepped over and walked around to the other side. Is that what you're saying?
Yes, sir. That's
Okay. So you
better
had
than I
one-
did with it, but that's
on
exactly
the other
correct.
side of the bed, and the physical layout would indicate the last coming in is the closest to the door, I would assume.
Which is where
Which is
the
where the
child
child was.
Yes, sir. Oh, beyond that, I don't really know that there is much I need to say. I do have.
Well, what if HAC does not? This court determines that we don't have enough for HAC.
If we don't have enough for HAC, we still have a victim under 12. I mean, we've got a baby. We've got a dead baby.
I
in this case.
understand.
We've got 2 prior violent felonies, 2 other first-degree murders. Even without heinous, atrocious, or cruel as an aggravator, this is a death case under this court's well-settled jurisprudence. I would suggest that we really should have 4 aggravators.
Well, that's on your cross appeal, but
Yes,
I
sir.
mean, really, it as our jurisprudence requires that the predominant reason for the murder be the witness elimination. Isn't that what it requires as a fundamental principle?
Yes, sir, and that's what he said.
And, well, so then it comes down to whether that was the primary and predominant reason for these other shootings.
Yes, sir.
And you say he said that's what it was. And
In his
where is
statement.
that fine? Where is that in his confession? Is that to
It's
the
in his
doctor?
confession, Judge.
In his
I've got
confession.
I don't remember the page off the top of my head. It's cited in my in-state's brief.
He told his psychiatrist that.
No, ma'am, he told law enforcement this. He tried to back up from it later on, but, it's a self-serving statement in my
Question
possession.
back on the HAC. I agree that it's proportionate without HAC. I agree with you on that, and without witness elimination. But in terms of if we found that HAC was erroneously found by Judge Eaton, wouldn't there be we'd have to find it to be harmless beyond a reasonable doubt, and since he imposed life for the mother, you don't know, when he goes to the child, he mentions 3 aggravating factors. So do we really know whether Judge Eaton would have found the murder of Ivory to be, to impose the death sentence without HAC? Wouldn't we have to send it back for him to reevaluate that?
No, ma'am. Because for the mother, there was only the one aggravated or prior violent felony. We've got a quantitative and qualitative difference in the aggravation with respect to the 5-year-old victim.
Because of her age.
Because of her age, which of course we, obviously can't have for the adult female victim. I would suggest, I said this in my brief, I'm not nitpicking at anybody, but, I do believe that witness elimination should have been found as to Ivory Hamilton. I also believe witness elimination should have been found as to Sarah Bukowski, but that's unappealable and I can't do anything about that. But we should be here on 2 death sentences at least, really. But we're not. But the bottom line, at the end of the day, this death sentence is clearly and absolutely proportional with or without the heinousness aggravator, and I am absolutely not agreeing that this murder does not qualify under its unique facts as especially heinous, atrocious, or cruel in the context of this case, which is the only one that makes any difference whatsoever. If the court has no further questions, I would ask the court to affirm the convictions and death sentence.
Just briefly, one correction. The responder neighbor was Yvette Bernard, not the other neighbor who talked about the shooting in succession. The state called 2 different people. Yvette Bernard, who was also a neighbor, who was the first on the scene, found the victims, but this neighbor had no knowledge of the shootings. And it was determined that there was no roofers that day of the shootings, so that the pops she heard had to be the gunshots, and they were in successive order.
Now, you've indicated that the evidence is that the shot for the child is just pure accident. Your opposition has said is that there's a confession that says that the reason, there's a reason for it, it's not an accident, is that to eliminate the child as a witness. Could you address that? It can't be both.
Well,
and we're now here to our facts. We ought to be able to agree on facts. We may dispute the law.
Yes.
But we need to know. What's the status of this record?
On page 146 in the record of his confession, he specifically says, shooting Ivory Hamilton to eliminate her as a witness had never crossed his mind. The witness elimination that they tried to cull from his statements, from his confession, was having to do with the mother. Because, as I said, he had done these 2 terrible things and she was still alive. And it went through his mind for the mother, but not for Ivory Hamilton, because he never admitted to purposely shooting her, ever.
Ever.
Never. He never, ever
now
once.
The question earlier in that little, the interrogation was, the question, the interrogating officer said, after you shot Ben, you were worried about Sarah or Ivory being able to identify you, that you had done this. Tell the truth. Were you concerned about that? And they weren't, and then the question, they weren't even supposed to be home. No. Okay, were you worried about there being a witness? Right. And he says, yeah. Okay? Mm-hmm. And that's definitely talking about the 2 of them. Now, later on, he does say that he hadn't even thought about the Ivory. But at one point there, he groups them together. And that's what it says, isn't it?
Well, it does, but I watched the confession. It's on video. You can watch it. And it's my argument to you that since he never purposely even admits to purposely shooting her, how could he have shot her for witness elimination? So it doesn't make any sense.
Sometimes people will admit to some things inadvertently. It's not on the script, but they will. That's not uncommon in cases such as this.
That's correct, but that's the evidence that you have.
You have Judge Eaton making a factual finding on it.
Correct.
It'd be different if he had found it and you were trying to knock out that
Yes.
And that's the same problem you may have with Hack, is he found something and now you're saying it's not
But
based.
if you look at the testimony of the neighbor, the quick succession is what makes this not EHAC.
How about the counsel says this is the situation of the room. I was asking him about the close quarters, and would it not require that the mother step over the child to get to the
I
location?
concede the mother was in the room before the child. I believe the mother came in before the room. I think his confession is over and over saying that she came in to see what happened before the child did.
Okay.
And was screaming, and when he went to shoot that way, she dove down to the bed and she shot the child. He shot the child. I don't think on purpose. Or if he did, it was without a whole lot of thought.
I know your time is up, but you keep talking about the quick succession of these gunshots. But as I understand, how quick could it have been if they were if they're the mother and the child, or in another part of the house, even in the next room, and they hear the shot and come in, and that's when another shot is fired? That to me does not connote quick succession.
Well, they quickly came back in the room because they just had left. They were just steps away from the door when the first shot happened, according to his confession. They were just steps away from the door. They had just left the room. Okay, thank you.
We thank both of you for your argument. The next case on our docket today is the Florida Bar versus Steinberg.
May it please the court, excuse me, may it please the court, Mr. Chief Justice, Ms. Brown-Lewis. My name is William Kent, and it's my privilege to present the argument on behalf of Greg Steinberg this afternoon. Mr. Steinberg has accepted the referee's findings of fact, so the issue here is simply whether the referee erred in recommending disbarment for Mr. Steinberg. The determination of the appropriate discipline is a matter, of course, peculiarly within the province of this court. And disbarment is, of course, an extreme form of discipline. It is the death penalty, so to speak, for an attorney. And it should be imposed only in those rare cases when rehabilitation is highly improbable.
Well, let me ask you why this isn't a demonstration of rehabilitation not being highly probable. You agree that Mr. Steinberg was under suspension, was suspended by this court, correct?
Yes, Your Honor.
He had not been reinstated to the practice of law when this misappropriation took place.
That's correct.
At a time when he should have been well aware that any other subsequent problems really was going to affect his reinstatement, he misappropriates this $8,500, is that how much it was, or $8,000?
Approximately.
Right.
Yes, ma'am.
And so at a time when he should have been well aware and trying to walk the line, if he was interested in reinstatement, he commits this offense. And so tell me why that doesn't demonstrate some problems with rehabilitation on his part.
Ms. Justice Quince, we don't dispute that some sanctions required. The question is, what's the appropriate sanction? So
What was the original suspension for?
91 days.
91 days, okay.
And so the question, I think, is, because I think, in effect, that question assumes that our argument in the brief is otherwise well-founded, and that argument is, if I can just address that for a moment, that there is no case other than the one case that the Bar Council found, the Bussey case, for which a lawyer, no reported case, in which a lawyer was disbarred for a theft of this type, which did not result in a felony conviction, because this is not the type of theft that of client funds.
So if you can talk the state attorney's office into not prosecuting you for what was clearly a theft because you either took the money to permanently or temporarily deprive the owners of the use of that money. If you can get the state attorneys not to prosecute you, then it's okay.
Well, I wouldn't say it's okay, Justice Quince.
You shouldn't be subject to.
Disbarment is the appropriate sanction. And I say that, it's not myself, but the cases. There are no cases that have upheld disbarment of an attorney on those facts.
Well, I think you see, though, we have, of course, cumulative misconduct
Yes, ma'am.
issues. So we had a prior 91-day suspension for falsifying a subpoena. I think that this court, correct me if I'm wrong, we increased the sanction to 91 days for this defendant. Is that correct or not correct?
I don't believe so. What happened, though, Justice Perriente, was when Mr. Steinberg petitioned for reinstatement, there was a proceeding in front of a referee judge.
Yeah, but was because this case sounds very familiar, it was the 91-day suspension. It wasn't, it was contested, right, by this defendant?
No, ma'am. What happened was Judge Weatherby, as the referee, had recommended that Mr. Steinberg be reinstated.
No, I'm asking for the 91-day suspension.
That was not.
That was uncontested? He agreed to a 91-day suspension?
Yes, ma'am. Yes, ma'am. And then he petitioned for reinstatement following that.
The record will show what it is. At that time, then, while he's under suspension, he embezzles money. He said he didn't embezzle it from his own trust account. Well, his trust account was frozen because he was under suspension. So he does the next best thing. He embezzles money from a homeowner's fund, of which he's in a fiduciary relationship. And then when he's caught, he uses a law firm check, which he's not supposed to have a law firm account going on because he's under suspension, to repay it. And when he petitions for reinstatement, he neglects to include the criminal investigation in his petition for reinstatement. So you're sort of saying, well, this is just a very forthright kind of lawyer that we ought to just give a very moderate punishment. But to me, it's the timing of these things that escalate what would be maybe a 3-year, maybe a suspension into disbarment, because it's happened at a point when he's already under a 91-day suspension for a serious act.
Well, I can't dispute the facts, Justice Perriente, but the question is this accumulation sufficient to constitute disbarment when the two separately, I think everyone would agree, are not sufficient? Really, the 91-day suspension was because Mr. Steinberg had dummied up some subpoenas that was looking for evidence that his wife was cheating on him. And so he issued subpoenas to get his wife's cell phone records to find out if she was cheating on him. That resulted in a 91-day suspension. And then
are you minimizing that particular action, sort of saying, well, didn't have to do with his practice of law? He was using the court's, the subpoena power that only that attorneys in an active lawsuit should have in order to get records. Are you excusing that conduct?
Oh, absolutely not. But what I'm trying to say is that it's quite a leap from what was an appropriate sanction, 91-day suspension, to then disbarment. And then the question is, does this?
But isn't the reality that we take a very dim view of people who are under suspension who misbehave while they're suspended? I mean, the suspension should get somebody's attention. It is a signal to them, you're not on the path you need to be on. We have not disbarred you, but you're going to have to get on the right path. And then, while under suspension, for a person to go out and take this money improperly, we have a responsibility to uphold the integrity of the bar. Now, we want to have sanctions that are fair to the lawyers who come before us to be sanctioned, but what kind of credibility would the bar have if we did not remove from the bar someone who engages in this course of conduct? And it's hard to fathom why someone who engages in this type of conduct, in this pattern of conduct, misconduct, serious misconduct, while under suspension, would then be able to have the possibility of coming back and being reinstated and not facing and not being disbarred.
Justice Kennedy, or Mr. Chief Justice, it's not we're not in any way minimizing, or I'm not seeking to minimize, or to say that a sanction is not appropriate, but just looking at it rationally and unemotionally, does the court need to go all the way to the most extreme sanction of disbarment?
Well, what would
under
you
these?
suggest?
Well, Ms. Justice Pariente, he's been suspended now for 3.5 years. Suspension order less than disbarment is what we're asking for.
I want to ask you about this, about whether we're minimizing or whether we're maximizing what happened. I'm troubled that not only, as Justice Kennedy said, that this happened while he's under suspension, but the referee's findings were that he made statements in the course of this proceeding that were not true, such as the fact that he said that the lieutenant who was investigating this became a weekly fixture at the office of the state attorney, where he would routinely rant and rave about why charges had not been filed against the respondent. And then he says there was the fact the attorney assigned to the case never saw that lieutenant in their office, never heard him ranting and raving, and how he was seeking to shift the focus. And then he says, and this is what bothers me in terms of the whole big picture, while some of the discrepancies in testimony could be considered minor standing alone, when viewed in the context of all the inconsistent statements and misrepresentations, they become more troubling. It's an indicator of a propensity for minimizing misconduct, for shifting responsibility for his misconduct, and for being less than honest and forthright. And then they say how he concealed from the bar the pending criminal investigation, telling the interviewer that he knew he would not be reinstated if the bar found out about the criminal investigation. That's serious. That gave me the context that it's like that's the nail. I mean, on top of that, he can't practice law, that he uses a law firm check to repay, that he embezzles money from a homeowners association. He lies when he's trying to get reinstated, because he knows that if the bar knew he was under investigation, they'd never reinstate him.
Ms. Justice Pariente, there are two things there I think that you're raising.
It's just justice is fine.
Justice Pariente, I'm sorry. There are two things there. One is, and we've tried to argue in the brief, misrepresentations that are going to be of the sort that would call for a sanction that is of disbarment have to be misrepresentations that seriously reflect on the attorney's ability to practice law. And the court in the Budnitz case, which the referee cited, the Budnitz case, this court said that the misrepresentation has to be, or implied, must be of a material fact. And what we've tried to say here is...
Can't you look at the fact that there were, it seems to me there were a lot of little, I'm not sure little, but a lot of misrepresentations. I mean, we've got the idea of him trying to shift the blame to a police officer, and then trying to shift the blame to the lady who worked at the bank about something which, in my estimation, was not even that important, which was who had the list of who had contributed to the homeowners association. And so you've got a series of these misrepresentations that really question, in my mind, whether or not this, your client is really honest about what is going on here.
But Justice Quince, about what was important, what I call material, was when he was confronted with the the misappropriation, he immediately admitted it, and he immediately the same day made full restitution.
When he's confronted with it.
Yes, ma'am. And so
but the fact is, he took it.
But are any of these other statements, though, that the referee made findings, are they really in any way material to the question?
Did he omit from the petition for reinstatement that he was under criminal investigation?
Yes, ma'am, but I don't know that
you don't think that's material? That you're not going to tell you're hoping the bar doesn't learn that you're under investigation, because what you do is you use a law firm check to repay, and and then you get the state attorney's office decides not to prosecute, you hope they won't find that out?
Well, all I can say there, Justice Parenti, is that the bar hasn't said, and I don't know that there is any duty on the part of the attorney in that petition for reinstatement to make a disclosure. There's not a catch-all question, are there any other matters that I'm aware of, and nor has the bar argued this.
Okay, you are now down to about a minute and 41
I better
seconds.
sit down, thank you.
Good afternoon. I'm Frances Brown Lewis. I represent the bar. Also at table is Joanne Stahlcup.
Ms. Brown Lewis, could you follow up on that last point about whether there is in fact a duty to disclose by a lawyer seeking reinstatement of a ongoing criminal investigation of the lawyer's conduct?
I think that rule can be interpreted to include such necessity to provide that information to the bar. One of the things when you're petitioning for reinstatement, the bar wants to know what's going on with your life since you've been out not practicing law. And the fact that you are under criminal investigation, it would just seem common sense that you should include that.
But is there some express requirement for that?
The rule doesn't specifically say that, but I think it can be interpreted to include that. The whole key is if the respondent who in claiming in the petition for reinstatement that he's fit for the practice of law, also saying that he's honest and that he's candid. If he's honest and candid, then he should have included in that petition the fact that he was under criminal investigation. The only reason
That probably wouldn't be a good time to apply for reinstatement. You're going to have to disclose that, would it?
the smart move would have been to dismiss the petition for reinstatement once he understood he was under criminal investigation.
Wouldn't he have to, whether he says he's under criminal investigation, does the bar want to know whether somebody stole money from an account?
Absolutely,
Okay.
because we as attorneys hold a position of trust. And if we can't be trusted to hold money, and it was clear he was holding this money for a specific purpose. And in fact, they put him on the committee as chair because he was an attorney.
Well, is there a particular question in the reinstatement application that you contend that it should fall within the requirement to answer that way?
Yes, there's a specific one. I don't know of it right offhand because it talks about criminal charges, if there are criminal charges pending. But another one of the provisions talks also about if there's any civil litigation. It would seem if you interpret the first one talking about criminal charges, they're talking about investigations of this nature.
Well, but there's a difference between being charged and being investigated.
I mean, there's a
Big
difference. But what we're looking for are attorneys who are forthright. One of the things the respondent has indicated was that as signatory, he had a right to withdraw money. If he thought he had a legitimate right to withdraw the money, why wouldn't he have put it in the petition for reinstatement? It was clear that he wanted to hide that fact from the bar. And if that was the only omission, I think we'd have a different story, or only misrepresentation. But we have misrepresentations throughout the course of these proceedings. And I want to clarify one thing. Respondent's 91-day suspension, as you've indicated, was for falsifying a subpoena. The referee in that case recommended 91 days. That matter came before this court on appeal, and this court upheld the referee's...
So he was trying, he didn't agree with the 90, he was trying to say it should be less than that.
Correct. The facts of this case, 2 days before petitioning for reinstatement, he took the last $1,500 from this account. 4 days after the effective date of his suspension, he took the first $1,000. So we don't have an aberration. We don't have an isolated event. We have 7 instances where he went to the bank and took money. In fact, on one day, he went to the bank in the morning, and in the afternoon, took additional money.
What was he, is there evidence in the record what he used that money for?
The respondent says that he used the money to pay his mortgage. The bar brought to his attention, well, 1,000 here, 1,000 there. What's your mortgage? And he said $1,400. Well, then he changed it. Well, my mortgage went up. He then changed it later to say, well, I also paid for some eBay courses and some other things to get me going once I got reinstated. Problem is, respondent will say whatever expedient at any given time to make himself look better. That's why he blamed the law enforcement officer.
And then when he wrote the check, I'm concerned, he wrote the check out of a trust account that was frozen.
He wrote the check he wrote the check from a line of credit, which said to basically the law offices of the respondent.
Oh, so it wasn't from his trust account?
It wasn't from his trust account, but it was from a line of credit that he got on his law practice. But interesting enough, he told one of the investigators in the internal affairs that he was going to use money that he was getting from the state to repay the homeowner's community provision. Well, he didn't do that. He got the money from the state, paid all of his other personal obligations, and then, oh well, I guess I need to get a line of credit. It's clear from the respondent's
Is a lawyer that's suspended not permitted to draw on a line of credit that existed before the suspension? We've seen some cases come through here, lawyers receiving referral fees and all kinds of things, living for years on referral fees coming in. Help me understand it.
He was supposed to remove all indications that he was able to practice law. That check gave the impression that he had the ability.
So it's because he put it into that account and then used that account?
Correct. He should have taken all indication on that check, blanked out, whited out the fact that it said law practices, I believe, of Steinberg.
Mm-hmm.
That should have been whited out.
But that's it. I guess now I thought it came out of his trust account, so I was mistaken. These seem, let's just in terms of trying to decide if disbarment's appropriate versus extending his suspension. The issue of the criminal investigation, although maybe he should have put it on, I think the way the bar is saying it, there wasn't an express question that would cover it. I mean, I don't think if the bar says criminal charges and there's no criminal charges, I don't know why somebody would think that they should include a criminal investigation, since obviously, he was hoping there wouldn't be charges and there weren't. The law firm check alone would not be significant. So are we going to the fact of the stealing of the money, and should we treat this stealing of the money as if it was being stolen out of his trust account, or is it different because it was not associated with his law practice, and it was paid back as soon as, I guess, they found him out? I mean, in other words, as to whether we should impose a 2-year suspension versus disbarment, and even if we made it prospective.
In the Bussey case, this court disbarred Mr. Bussey. And Mr. Bussey was a fiduciary of a bank, and he basically stole money. The court basically treated it as if an attorney was holding funds in a trust account. And I believe it's analogous. We can make that analogy that when you hold money in a fiduciary manner, such as Mr. Steinberg, then that's like holding trust monies. They should be sacrosanct. They should only be used for the purposes.
But the fact that he, in terms of whether this disbarment, the fact that he repays it, so there's restitution made, correct? I mean,
restitution was made.
And it was made from a line of credit that, although he shouldn't have used the law firm check, it was a legitimate line of credit. If we, whether we dispar or we give a immediate or we extend a suspension, what is the date that should be used for the punishment? If he, at 91 days, when he petitioned for reinstatement, do we look and say, well, he's been out for 3.5 years now, so do you extend the disbarment? I mean, if it was a suspension, another, say, 3 years, he'd be out for 6.5 years. Or how does the bar look at that? What should be the date that we
the date should be the date of this court's order. He shouldn't get credit for sitting out because of his own misconduct.
But doesn't that make then whether it's a suspension or disbarment longer? Because again, if it was done in a more expedited manner, not anybody's fault. We're hearing this for oral argument because it's a serious matter, but I guess I'm always concerned about that when somebody's already been out on a 91-day suspension for 3.5 years, how that justifies going from the date that we ourselves issue the order, which is, again, extending something potentially 8.5 years, when now he would have to take the bar exam, and then have been out for all that time. So I just don't, we've probably had these situations.
Part of the transaction costs for theft.
But isn't our case law indicates that at worst, it goes back to the disbarment entered by the referee. That's the date that controls, isn't it?
I don't really know right
Because
offhand.
if not, then what you're doing is penalizing someone a number of years, whatever it takes to get through the appellate process. I thought we had a standardized process for this, and I thought that that's the way that these were entered. We don't take it from the date of the event, but we certainly have never just applied the date of a decision of this court. To my recollection, I could be wrong, but
And you might be correct. I really didn't look into that.
Okay.
The issue for me is we wouldn't be in this position if the respondent had not taken these monies and had not lied about
there's
it.
just no question. Let me tell you what. I hate these cases. I hate these cases, and my heart breaks for a brother lawyer that's in problems. And we can't just let these things get by. I mean, I look at it. Here's a man whose life fell apart. His family life's gone. I mean, that the heart of who he is as a person is gone, and then starts going into accounts that he knows he ought not have been in those accounts. He knows it. And so what do you do? I mean, that's the question that we face. That's the question that we face here. Some people come up and they throw, I got drugs and I got this and I got here we got a guy whose life fell apart.
His life fell apart.
Yeah.
That's true. And in those difficult situations, I think that's where you find out who you are.
Yeah.
You find out whether you will still be honest, whether or not you will still be forthright. Whether you would take the easy road or whether you would take the hard road.
Okay.
And one thing that this court has always looked at is the next person who might be in these same circumstances, what would they do?
Yeah.
Also, what is the public's perception of attorneys who steal money and then lie about it? Looking at all these factors and whether or not it's likely that the respondent will be rehabilitated, I think the evidence clearly shows he won't be, because if he ever...
Is this truly, there was some mention about funds owed from the JAC, which means that he had done some representation of clients, if it's true. Was that the status that JAC owed him some substantial dollars
the
for
JAC
work that he had done?
Yeah, prior to his suspension, and they owed him
Right.
about $29,000.
Okay, and that's Bar agrees with that. And was never paid, or what happened? What happened with that?
He got that money. Instead of using that money to repay the homeowners, he used that money to pay his other obligations. He didn't make it a priority.
What was the time frame there? What was do you have in your record, or do we have in our record, the time frame of when he got the money from the JAC and when the $8,000 was taken from the committee account?
The information that we have, we know when the money was taken from the account. It's clear
it started right after his suspension.
Correct. The first withdrawal was March of 2008.
And that's when he was suspended.
When he was suspended, 4 days after the effective date, then he took the first amount of money.
And then
from the information that we have, the check came in probably around late April or May. There's some discrepancy as to exactly when that check came in, but it is clear that he got that money and did not pay the homeowners association.
And then the next question in this whole sequence of events is, when was the money actually paid back?
The money was paid back around May the 6th, and only after, in the bar contents, it was after the vice chair contacted law enforcement about the missing money. And then law enforcement contacted Mr. Steinberg. He then repaid the money using a check from from the line of credit. Bottom line is, I believe that the referee's recommendation is supported by the case law, by the standards. Veracity, honesty is the hallmark of attorneys. Attorneys need to be trusted in their personal life and in their professional life. The respondent has not done so. Based upon all the information, evidence before us, the bar believes that this court should disbar him. Thank you.
Very quickly. Justice Kennedy, you're asking what's the public require for a case like this? I know this court has to make the decision, but the judges who knew Mr. Steinberg, first Judge Weatherby, when he petitioned for reinstatement, Judge Weatherby was the referee. All of this came out in the hearing before Judge Weatherby, the taking this money, all the facts. Judge Weatherby, knowing all those facts.
At the reinstatement hearing?
Yes, ma'am. Judge Weatherby recommended he be reinstated. Now, this court overruled that. But Judge Weatherby, who knows the man. Then at the 2010 hearings, we had 3 local judges who came and spoke on behalf of Mr. Steinberg. And these are the people who know him best. And so in terms of these misrepresentations, they're not really material. As soon as he was confronted...
I was looking at what the judge found in mitigation. He found timely good faith effort to make restitution, but then there's no... you don't appeal on the failure to find mitigation. I mean, there's no... we have to call the record back to see what mitigation are you saying justifies a lesser sanction?
Justice Perriente, I mean, this court determined, so I think the referee's assessment...
So what did the judges say? He was a good lawyer in the courtroom? Is that the gist of it?
With their knowledge of his character.
Well, but I'm sure when the question was asked, well, did you then know that he stole money from a homeowners association account? I mean, you still have the same good view of his character? Doesn't that... I mean, doesn't that trump, isn't that what the referee said? Isn't it what the bar is saying?
Well, the judges weren't there, Justice Perriente, to say these shouldn't be sanctioned, nor am I. The question, though, and why the judges were there were to speak on his behalf that he not be disbarred.
Who were the judges?
Judge Tinlin was one, Judge Berger was the other, and Judge, I'm drawing a blank, I apologize, Judge Alexander. And so those were the 3 judges. And then Judge Weatherby, I say, recommended that he be reinstated knowing the facts of this case. He did immediately, the very day he was confronted with this, that day within 2 hours, I think the record shows, he made full restitution. This case is so far away from Bussey, which is a case that the states relied upon. It was a multi-million-dollar international conspiracy. It went on for years. Mr. Bussey was a director of the bank. He didn't even respond to this court's order for briefing on his proposed sanction. He was disbarred. There's no case like this other than theft of client funds or law firm funds or trust account funds where a lawyer's been disbarred. And I recognize it is cumulative. I recognize this is a serious sanction is called for. But
again, I'm having still just you're out of time. Are you saying that we shouldn't look at what he did vis-a-vis the bank? I'm sorry, the homeowners association, as if it was his own trust account?
Yes, ma'am. Because I mean, it isn't a trust account.
We should, and even though they gave him these funds or had him in this position because he was an attorney.
Well, it was a dormant fund that had been sitting dormant for 6 years. I don't think
that justifies stealing out of the account?
No, ma'am, but it's not a trust account. I mean, just differences matter.
It was still other people's money.
It was. Well, any time it's a theft, Justice Quince, of course, it'd be someone else's money. So.
All right. Well, we thank both sides for your argument. The next case and the final case on today's docket is DK Arena Inc. versus EB Acquisitions LLC.
Good morning. Good afternoon. May it please the court, I'm Alvin Davis from Squire Sanders and Dempsey. I represent DK Arena in this matter. This is a fairly narrow issue, a situation in which the 4th District found that promissory estoppel was a sufficient basis for overcoming the application of the statute of frauds.
Did they say promissory estoppel, or did they say estoppel?
They did not, the 4th District did not characterize it as promissory estoppel using that term, but they referred, and EB referred to the promise made by Mr. King. He promised to extend the due diligence period. So it fits within promissory estoppel, not within equitable estoppel.
Well, I have a question on that.
Yes,
And I think this, maybe it's just an academic point, but as I understand equitable estoppel, that is a name for a very, very, very broad category of cases, which would include other types of estoppel that are equitable in nature. Am I wrong in looking at it from that perspective? Promissory estoppel may be one form of an equitable estoppel. Part performance may be one form of an estoppel that falls under the broad umbrella. How would you instruct us? What is the academic position with regard to just the fundamental term of an equitable estoppel?
Broadly interpreted, estoppel is estoppel, and promissory estoppel is a form of estoppel. But for purposes of this case, for purposes of the Tannenbaum case, they make a distinction between promissory estoppel, in which you promise some future event, and equitable estoppel, which is customarily referred to as a changing a position from a statement of fact. You're stating a fact now, and then later you change your position. That's when equitable estoppel comes in.
So you would define then an equitable estoppel as a very, very small, finite category then?
Well,
is that you believe our case law has done that?
I believe that's what the case law says.
Okay.
And my question on it, and I go back to the Tannenbaum case, which involved no written contract whatsoever. Wasn't that the case in
Yes, Your Honor.
Nothing in writing. Here is a written contract that complies with the statute of frauds, and then there's this due diligence period, and it was no question it was extended in writing once to October 4th.
Yes, Your Honor.
It was clearly not extended again in writing, because if it had been, we wouldn't be here.
Yes, Your Honor.
However, October 4th, discussions take place. That's when it would have expired. October 5th, Mr. King appears before the city or county commission. I guess, was it a city commission or county commission?
City, Your Honor.
This is Addie Green. Wasn't she a county commissioner, or was she a city commissioner?
No, city.
Okay. And and he's promoting this. So he clearly, at that point, the contemplation is we're waiving this expiration of this due diligence period because we're speaking in favor of the contract. And so if we're going to start to parse out, and of course, I think Judge Gross tried to parse it in a different way. As you said, this is a big deal in the term or a not big deal term.
Yes, he used an essential term distinction.
Yeah, which I see your point there. But if we're going to be saying what the statute of frauds is meant to do, which is to have contracts in writing that involve, in this case, the sale of real estate, and we have that. But we've got a party to this that has the right to have said the period has expired, but instead acts in furtherance of an extension that the person relies on. I'm having my hard time seeing why the equities of that situation don't at least qualify. And I was looking at the case this morning of Forbes versus Babel as the waiver of something that would have otherwise benefited the DK, which is you only have 60 days for due diligence and it's expired. And in fact, no, they go ahead and they act in furtherance. So tell me from, I guess, both the facts of this case, what's wrong with it, and then why, as a matter of jurisprudence, it would be it is wrong to include whatever you call this kind of estoppel as an exception to the statute of frauds.
First, factually, there was an oral extension from the 4th until the 11th. There was testimony in the record to that. The more important testimony is that on the 11th, the representatives of EB met with the representatives of DK, acknowledged that the due diligence period was expiring on the 11th, and requested a further extension of that. This is unrebutted in the record.
But you would say that under the statute of frauds, that they couldn't have extended it verbally from the 4th through the 11th.
I would say that, and I was met with that as a fact of what occurred. Since I've been representing Mr. King for 15 years, I was not surprised that that had occurred. But it was a limited extension, because what the court is talking about, what EB is talking about, is an endless extension of a due diligence period, which takes the property off the market indefinitely, which Mr. King testified he was not willing to do. The important factual issue here is, and I think it's a very significant factual issue, is that in the conversation, and it's in the record of the transcript at pages 171 of the trial transcript, the testimony, unrebutted testimony, is that there was this conversation between the two sides, at which point the lawyers for Mr. King, I was not involved then, but the lawyers for Mr. King, the property lawyers, said to, he's now Congressman Klein, it's expiring today. The due diligence is expiring today, and Mr. Klein acknowledged that fact and said we need a further extension.
And what date was that? Was that on the 11th?
On the 11th, yes.
But I thought, I thought your argument was that the actual extension expired on October 4th.
But for the verbal extension for one further week.
Okay, and that verbal extension occurred on what date?
On the 4th to the 11th.
But the judge found on page 4 of the judge's order, and there was testimony, the court finds the due diligence period was extended at the October 4th meeting for an indefinite period.
Yes, he did.
Okay, so isn't that a factual finding? I mean, we're here really not to reweigh the evidence, but take the evidence in the light most favorable to what was found based on the credibility of the people involved, and then say whether the statute of frauds, which is a legal matter, trumps all of that, so that it wouldn't matter whether it was extended from the 4th to the 11th, from the 4th to the 28th, from the 4th to the 12th, never that you can't do it. That's what your point is.
That's my point.
So
let's assume that expired, that the due diligence term expired. So then at that point, the contract has to be complied with, right?
Yes, Your Honor.
So why isn't then the trial judge's final judgment on page 7 there, in effect, where it says that Mr. King promised that he would attend the October 26th council meeting, and his failure to do so violated paragraph 14 of the agreement?
Your Honor, the trial judge created an oral joint venture in his ruling that neither side had addressed, and as to which there was no evidence.
Aside, this has to do with the original contract, not the oral joint venture agreement. The original contract in the record requires, under paragraph 14, compliance and cooperation of Mr. King, and he found a violation, the trial judge did, of that particular provision. Not a joint venture, but the original contract. So why shouldn't we look to that, as the appellee argues, and say that, look, there was a violation of the contract here, so according to the terms of the contract, there ought to be a return of the deposit?
Well, the problem with, and I understand the court's position, the problem is that the trial court ruled that the basis for extending the due diligence was this joint venture that he created, which the fourth DCA rejected. He mixes and matches here. It's difficult to understand
But
the
isn't,
opinion.
you're going back to the joint venture, but isn't the finding on page 7 of the judgment having to do with the original contract, not any terms of a joint venture agreement?
He's going back to the original contract.
Correct. Not
Yes,
the
he
joint
is.
venture, the original contract.
But he then found a breach for which he required Mr. King to pay all of the attorney's fees, which the fourth DCA reversed.
Well, I'm talking about the deposit, the $1 million deposit. Why shouldn't that be returned back to the to EB?
Because the so-called breach by Mr. King wasn't the basis for the return of the deposit. The return of the deposit depended upon whether the contract had been terminated or not. The contract.
I'm sorry, I'll let you finish. I thought you were done. But
Close enough to be.
let me go back to kind of a preliminary question here. And this kind of follows up on something that Justice Perrietti asked about Tannenbaum. I have trouble seeing express and direct conflict between Tannenbaum and the case on review. I mean, we've got, it seems to me to be an entirely different thing to use promissory estoppel to totally get around the requirement of the statute of frauds that an agreement be in writing. That's one thing. It's another thing to allow a waiver or an estoppel to operate, however you want to describe it. And I don't think the terminology really is what should drive this. So I have trouble seeing the express and direct conflict. Obviously, at least up until now, I would be in the minority on that because I think 5 judges, the justices decided we have jurisdiction, I think on the basis of Tannenbaum. But is there some other case where there's express and direct conflict? If Tannenbaum doesn't do it, and I understand you would assert that it does, but beyond that case, is there another case that you would rely on for that you could tell me for express and direct conflict?
Well, this court decided in W.R. Grace where it reinforced the holding in Tannenbaum. There are, and we cited 2 other cases from the 4th District where Tannenbaum was...
The fourth won't do it.
In this court, no, Your Honor, I cannot.
And Crown really recognized there's a difference between at least equitable and promissory, but then said promissory could be used to create insurance coverage. So I think, and I follow through with what Justice Kennedy is saying, because it's my concern as well, that if we're dealing with some absolute with the statute of frauds, that any extension or waiver of a written contract has to be also in writing. No, unless there is a actual misrepresentation, that would be your, that someone relied on. There has to be an affirmative misrepresentation. Then here, again, in Tannenbaum, it is, now part of the contract was in writing, and the issue is, should the whole statute of frauds be excused because somebody came down to Florida and had to spend a lot of money to become a doctor and couldn't get the agreement in writing? Just doesn't seem like we set up this absolute rule that is therefore the reason to quash this case. I mean, maybe it is to elaborate on, Judge Gross's theory of what kinds of estoppel are permissible and what aren't. But that's, so if you could still address that issue
I would refer
about some hard and fast rule that we have adopted and stuck to all these years about the statute of frauds, and that every part of a contract, even excusing a part of it, has to be in writing.
Well, my preference would not be for an elaboration of Judge Gross's opinion, but a rejection of his opinion.
I'm saying an elaboration of Tannenbaum to say that
Yes, I
it
understand.
applies across the board to any kind of a situation other than, and we would just be making this up as we go, something that we'll call equitable estoppel, which in your view is a smaller subset of estoppel, different from promissory estoppel, and different from waiver.
I'm just going by the definition of equitable estoppel in the case law, and equitable estoppel in the case law refers to a misstatement or a concealment of a fact. Promissory estoppel refers to a promise of something that is going to happen again in the future.
But what about, again, the idea that, again, Tannenbaum had nothing to do with this issue, which is that somebody isn't refuting a contract that exists, but is not insisting on a, and again, I realize your view of the facts may be different, but based on what the judge found, but agreeing to waive a specific provision of the contract.
Well, if I may, and I don't mean to be hyper-technical, but this is the Supreme Court, waiver was not addressed by the judge. Waiver was not addressed by the trial court. Waiver was not addressed in the briefing of this.
But most respectfully, if you can affirm on any basis,
I understand
you
that.
do that.
That's happened to me here, so I
You're
understand
down to 4 minutes.
very well. Okay,
You can continue.
let me just respond to your question. There are a series of cases that we've cited here where it didn't deal with the situation of poor Dr. Tannenbaum, where nothing was in writing. There are a series of cases where there are a number of contract provisions, and the statute of frauds was held to apply to an extension of the closing date, which is very similar to this, to an extension to obtain financing terms, to an extension.
Those are lower court cases?
Yes, they are all lower court
and
cases.
So you're saying that the Fourth District opinion is in conflict with those cases?
Yes, it's in clear conflict with those.
What's the best case from a lower court that this case is in conflict with?
Wharfside, Shore Holdings.
Well, Wharfside's the Fourth District.
I'm sorry, you said this court?
No, you say, if we have to have conflict, it has to be from another appellate court.
Yes, I understand. It's in
it's
conflict with...
possible the Fourth could contradict itself, but that's not the basis for our
We can't do anything about it.
No, it's not helpful, but it doesn't, you can't do it. The Coral Way decision, the Bradley decision, both from the Third, City of Orlando decision from the Fifth, all are consistent with Tannenbaum.
I agree with my colleagues that cases ought not be determined based upon labels. And that's what's going to my initial question here. I think there's a significant legal issue that the law in Florida is really confused with regard to the statute of frauds and when something happens, whether it avoids it, whether it's an exception, and what happens to it. And I think that we're all over the board on that.
Well,
and we do need some clarification.
There is no question about that, both in terms of what's equitable estoppel, what's promissory estoppel, when does it apply, when doesn't it apply. And this case illustrates nothing so much as the fact that there is clear confusion, not simply in the Fourth, but elsewhere. My preference would be to have it reversed, but it is also a useful result to have this clarified by the court, which frankly was my belief that that's the reason the court took the case.
I agree with you. What is an exception? What is a reason, a legal doctrine, to avoid the application of statute of frauds, as you see it coming out of this case?
I don't think that there should be. I think that the law that was enunciated in Tannenbaum is pretty clear. I think that the carve-out by Judge Gross provides no guidance to anyone. What is an essential term? I think giving up the right to $1 million deposit and extending due diligence indefinitely would be an essential term. He doesn't say what an essential term is. He talks about the two cases where they clearly affirm Tannenbaum and follow Tannenbaum, and then says, but those were essential terms, this isn't. That's of no guidance to anyone.
May it please the court, Kevin Marco from the law firm of Becker and Polyakov for the respondent, EB Acquisitions. The Fourth District's decision in this case did not recite any new law. It does not conflict in any way with any decision of this court, any of Florida's district courts of appeal, or frankly any other jurisdiction. The law recognizes and has recognized for years the peaceful coexistence between the statute of frauds and the doctrines of waiver and estoppel.
This case wasn't decided on a waiver.
Well,
was this case decided on waiver?
It wasn't decided on a waiver.
So the judge has created some body of law that wrote this opinion with regard to estoppel. As I read the opinion, as any lawyer in Florida will read that opinion, it talks about estoppel, and it talks about something called essential elements or essential requirements, something like that. I forget the phrase.
Well,
That's what caught my eye in this case, is that, as far as I'm concerned, in looking at that, is that you could almost say anything, any fact in the world will avoid application statute of frauds, as long as we just give it a label. That's what my concern is.
Well, Justice Lewis, with respect to the waiver, there is a synergy between the waiver of DK to rely on the strict performance of the contract as written and the estoppel to prevent DK from relying on the statute of frauds as a defense or offensively.
Well, respectfully, I think they're two different things. I think the law is always recognized, and estoppel and a waiver is different, and the essential element is that a waiver is a relinquishment of a known right, but estoppel requires a change in position.
But the trial court did.
Is that not the legal distinction between the two?
Of course it is.
Okay, well, so I mean, they can't be the same, so we know they're not the same.
Well, there are actually two distinct doctrines under which this court could affirm.
Did in the trial court, did did you sue for the return of the deposit, your client?
We sued for the return of the deposit.
They raised the statute of frauds?
The statute of frauds was an issue that
Okay,
was
and as
argued.
an avoidance then, what did you plead?
We filed a counterclaim for breach of the contract. We also raised affirmative defenses, raising waiver and estoppel.
So that was in your original pleadings? I mean, and I agree that there's, I just always, I'm not quite at law schools a while back, but that we always used to say waiver and estoppel as if they were somehow, could be, in this case, either you waived compliance with the condition or you were stopped from asserting it. I guess those, I see those as two different things, but you say you pled them both.
We pled them. The fact of the matter is the evidence all came in as several of the justices have recognized already
But no
today.
one actually found, not the trial court nor the district court, found that there was a waiver in this case.
That's true, Justice Quince. However, the record clearly does support a waiver with respect.
I'm just asking you, that's a fact. Neither court found that there had been a waiver in this case.
No court has specific. Yes, I agree. No court has specifically found a waiver. However, the trial courts.
And when you look at the 4th District opinion, 4th District does use the term estoppel or estopped, correct?
Yes, it does.
Okay. So my question to you is this. Is there a real difference? Is there a difference between promissory estoppel and equitable estoppel? Because otherwise, it seems to me, if there is no difference, then you could eliminate the statute of frauds altogether and just, go with this. Because I thought promissory estoppel, and you can correct me when you get to answer here, that promissory estoppel involved a promise that you expect someone to rely on, and they did, in fact, rely on it. Whereas equitable estoppel involved some kind of misrepresentation of a fact, and that's the equity that allows you to circumvent the statute of frauds. And just, if you would tell me your understanding of the difference between promissory estoppel and equitable estoppel.
My answer would be in line with the questions that Justice Pariente was raising, that I don't believe this is a promissory estoppel case. Based on my experience, I believe promissory...
But there was a promise in this case, or that's alleged, a promise to forego to extend the due diligence period, correct? That was the promise.
Well, yes, that was a promise. It was also the established fact of the case. I mean,
then wasn't that what was relied on? That's why I'm really having a hard time understanding here exactly what the 4th District meant when they were talking about estoppel. So that's why I'm trying to get you to explain to me the difference between promissory estoppel and equitable estoppel. Waiver aside. I
Sure.
don't want to get into that right now, but what is the estoppel here that the Fourth District found?
Well, the estoppel was EB's forbearing on its right to terminate the contract and request the deposit back, as was its right to do. Promissory estoppel, I believe that the courts have defined as a substitute for consideration, or as this court recognized in Tannenbaum, is the substitute for a contract. In Tannenbaum, there was no contract, and the plaintiff therefore was...
You mean a written contract?
There was no written contract that was right within the statute of frauds, and as several members of the court have already identified here, there was a written contract.
But the forbearance was in exchange for a promise to continue in joint venture discussions to try to come to an agreement there. So it seemed like it's just an absolute modification of the written contract that the statute of frauds would apply to.
Well, as the courts recognize, and it really does speak to the lack of conflict and the harmonious existence between Tannenbaum and all of the district courts of appeals which have decided the issue.
So are you telling me that the district courts have not looked at the Tannenbaum case as saying, in essence, that when you have a contract, a written contract, and there's a provision that says that any addendum has to be in writing, also that promissory estoppel is not cannot be used to circumvent the statute of frauds? That's not how the district courts have looked at Tannenbaum?
Well, the cases which have upheld the doctrines of waiver and estoppel in this under these circumstances, and it's the question that Justice Polston was alluding to, provide that the estoppel prevents the unjust application of the statute of frauds, but the reliance, the terms that are relied upon, which were in this case the extension of the due diligence, in the other cases that the other district courts of appeals have decided have been extensions to the time for closing. Those terms do not become part of the contract itself. The contract itself is the purchase and the sale. The consideration hasn't changed, but what changes is the conditions under which the purchase and sale shall take place. The same promise under different conditions. And that's been the holding of, if you go through the cases that we relied on, the second DCA in Young versus Pottinger.
Would you answer Justice Quince's question? I mean, she asked you the difference. Would you tell us the legal difference between promissory estoppel and equitable estoppel? That's where she started. Could you just answer that simple question? And she told you what she understood it to be legally.
Okay. My understanding is equitable estoppel is detrimental, estoppel, period, and it certainly falls within the broader label of equitable estoppel, is detrimental reliance, which has been induced by promises of another party.
Well, is that commonly, generally, legally known as promissory estoppel?
No.
It's not. What is that known as?
That's known as estoppel.
Well, but whatever it's known in Tannenbaum, we called it the so-called doctrine of promissory estoppel. And we cited to the restatement of contracts to state it. Now, I don't know where we ever said, but equitable estoppel can be an exception. And we certainly didn't say in Tannenbaum, although there is a pretty good dissent, I mean, it's 4-3-4-2, but no one's asking us to recede from Tannenbaum here, but that we didn't talk about equitable estoppel. So the only holding of Tannenbaum is that promissory estoppel is not an exception to the statute of frauds, being a promise which the promisor should reasonably expect to induce actions or forbearance, and which does. Here, the promise was to extend the due diligence period, and they acted in reliance on it. That's the promissory estoppel. There's nothing in Tannenbaum that says, well, it's only if it relates to the actual material terms of the contract. Each part of the contract, including a due diligence period, including a time for closing, are all part of what needs to be in writing under the statute of frauds, doesn't it?
Yes, Justice Periente, and it was the question that the answer that I addressed to Justice Polston. Basically, the consideration remains unchanged. It's just the manner in which the contract is going to be performed. And
Well, what was the consideration for this so-called indefinite extension of time of the due diligence period? What was the consideration?
It was forbearance. It was forbearance by EB of its right to pull back the $1 million deposit. And it wasn't a change.
No, I mean, okay, what did EB get in return?
It got an open due diligence period so that the parties could pursue their joint venture discussions where King was going to provide seller financing and retain equity in the deal.
What did DK get out of it?
Forbearance to keep the contract alive, as opposed to having them pull it back. I mean, that's right.
Yes, Justice Kennedy.
I mean, the thing that, I mean, in trying to get stability in Florida law, I mean, we can't have just, the law is that we have a statute of frauds, but it's a phantom, because every time you can come along and we can change it by we'll promise this or we'll do that, and there is no such thing. And we're even expanding statute of frauds now, what, in the UCC? Even further than from real estate contracts. This happens to be a real estate contract. So my concern is the stability in Florida law, a clear statement of no such thing as promissory estoppel to bar application of the statute of frauds. Isn't that what Tannenbaum says?
Well, I think that would be an extreme reading of Tannenbaum, given that it wasn't a real estate case, there was no written contract.
It was the statute of frauds question, wasn't it? Couldn't be performed within a period of a year.
Yeah.
Okay, wasn't it?
Yes.
Okay, so the same statute of frauds, whether it's a land deal or 5 years. I mean, we're not going to get anywhere here if we're just trying to make exceptions, because this court is not in the exception business. We're trying to stabilize Florida law.
Well, let's look at the court's own precedent. I mean, Tannenbaum was decided in 1966. No mention was made in Tannenbaum of Gilman, which this court held in 1945 that the statute of frauds can't be invoked where non-performance was caused by the other contracting party's oral agreement.
Well, now, I guess here's the issue. You're suggesting we should discharge jurisdiction. You're not suggesting that we recede from Tannenbaum or that it was wrongly decided, or are you?
Well,
because that's now we look and say, yeah, that's 66, that's 45, Forbes is 53. We need to bring, clarity. But I go back to this, although I don't like what happened here, the idea that they knew how to put an extension in writing, they did it once. All they had to do, if they thought they were going to extend it, this isn't like something that would be difficult to do, is spend 5 more minutes and put it in writing.
Well,
and if somebody wasn't going to put it in writing, then you'd be thinking they're trying to snooker you. That maybe that's what happened. Maybe Mr. King, he was obviously playing it. He was negotiating with other people. He was promising to do one thing, and none of that seems like terrific behavior. But the issue is that the court or the law says if something is going to change in a contract, you got to put it in writing in a real estate contract.
Well, as to the first part of your question, Justice Periente, we did write in our brief about what we found as the emerging trend in promissory estoppel law, where many states, and we had a long string cite in our brief, have started looking at the doctrine of promissory estoppel as a mechanism and a tool to prevent the kind of injustice which perhaps the plaintiff suffered in Tannenbaum. But to affirm, the court need not refrain or repudiate Tannenbaum at all, because there is a direct line prior to Tannenbaum, which was undisturbed in Tannenbaum, Gilman, Forbes, interestingly, South Investment Corp., which was a case relied upon by DK extensively, the court wrote. And I think this really gets back to a question that Justice Lewis was raising as to the doctrine of estoppel, and that's what I called it, to prevent the unfair circumstances which the unjust application of the statute of frauds may occasion. This court wrote, the doctrine of estoppel, when invoked for the purpose of working a change in the title to land, is to be applied with great caution. It permits verbal statements or admissions to be substituted in place of the written evidence of transfer, which the statute of frauds and the general rules of law require. So And subsequent to Tannenbaum, you had United of Omaha, which was the third DCA. That was the same court that certified the question in Tannenbaum, which this court decided. Married.
Doesn't this case, to me, this case sort of is a poster child for why we shouldn't have these kinds of exceptions to the statute of frauds. Here we have one party who says, yes, we talked about extending this due diligence period, but it was only for 7 days. And we have the other party saying, yeah, we talked about this extension of this due diligence period, but it was for an indefinite period of time. If we had reduced this to writing, we wouldn't have this kind of dispute. And so, all of this just really brings to my mind that these exceptions that we've been carving out for the statute of frauds are consuming the statute of frauds, so why in the world do we even have it?
With all due respect, Justice Quince, there have been exceptions to the statute of frauds since the statute of frauds was created.
I understand there have been exceptions. I'm just saying, if we're going to get down to the nitpicking about waiver, about equitable estoppel, about promissory estoppel, or whatever kind of estoppel you want to call it, then why are we messing with the statute?
A couple of points and one suggestion. First off, it's been recognized back to Cardozo and English common law that the statute of frauds shall not be used as an instrumentality of fraud or a stumbling block on the path.
Well, that goes back to Justice Quince's original question, is misrepresentations and fraud. We're not talking about that in this case. We're talking about, well, there's a different agreement than what we have in writing. That's what this is, isn't it? You're saying the agreement is different than what this written document says, and here are the facts. And the other side said, no, it's not. But that's not a fraud. That's a dispute with regard to the facts.
It was as the New Hampshire Supreme Court found, that was relied on by the Fourth and was also cited by the Second DCA in Young and Pottinger. The terms of delayed performance do not affect the contract itself. And that's a distinguishing feature from Wharfside, from Shore Holdings, which the court didn't allow my opposing counsel to argue because of the lack of conflict within the Fourth. But for decades, courts have recognized, the treatises have recognized, that the party can't benefit from altered performance which was induced by their representation, that they would accept altered performance. And back to Justice Quince's question.
I want to make sure I get two questions in on you. First, isn't it your position that even if your opponent wins on the estoppel argument and that the statute of fraud applies here, that you're still entitled to the return of the deposit because of the breach that occurred by Mr. King not going to the commission meeting?
Clearly, Justice Polston.
So even if the statute of fraud applies, then you still win your deposit back?
Yes. On this record where the facts are all established, there is one possible way that DK could make an argument. It's an unsustainable burden. The only way that they can make the argument, and I didn't hear it today, is that on October 4, all duties under the contract just ceased to bind King anymore because the money just didn't appear in his hands. And frankly, there was no obligation under the agreement.
But if that's the case, it seems to me that why is there then still an obligation to appear 22 days later? I mean, if the
because the contract's still in effect. I mean, the due
Wait
diligence.
a minute. If in fact there was no extension of the due diligence period beyond October 4th, it seems to me that then there's no obligation, and that it's now time to either, carry through with the contract or not.
But
the obligation.
I'm sorry. I apologize.
Then the obligation. Tell me why you still have the obligation on October the 26th.
Because unilateral action with respect to the delivery of the deposit was not something that was EB's responsibility. If you look to addendum paragraph 10, which is really the only contractual argument that DK can make, addendum 10, paragraph 10 says, at the end of the due diligence period, assuming that buyer has not given notice to seller that it intends to terminate the contract, the parties plural, not unilateral by EB, shall take the following action. The deposit shall be released to seller, and the seller shall deliver closing documents and other records regarding closing. That was never done. But let me just emphasize one other point. Subparagraph A of Addendum 10 does not require EB to deliver the deposit. EB didn't have the ability to deliver the deposit. The deposit was in the hands of an escrow agent. So up until the time where King failed to appear at the dispositive meeting, at the meeting that he didn't attend, that doomed the project, EB never had any notice that the release of the deposit was something that was material to King, that King's participation in the project was at risk because of the failure of the deposit to magically appear. EB never took any action, nor does the record show any conduct whatsoever by EB where it opposed or prevented the deposit from being delivered to King.
When do you say the contract terminated? When did you say that one part or the other, well, it couldn't have been, when DK says it was terminating the contract?
I'm sorry, I didn't hear the question.
When was the contract by, because as I now realize, and I may have misstated in my own mind some of the facts, if the only thing this due diligence period says is whether or not they get their deposit back, but as of the date that King is supposed to appear, there's an ongoing contract, isn't there?
Yes, the fourth DCA specifically addresses it, and it really, I'll use language different than.
So if the contract is in existence, the only thing that has been lost by what's lost by DB is that they can't, if they breach it or they want out, they don't get their deposit back. Is that correct?
Did you say DV? He's even EB gets its deposit.
I'm sorry. That's I've been. It's too close. Yeah, EB and DK. I've probably been doing that all morning. So it's although afternoon. Yeah, that as far as EB, who is your client, correct?
Yes, Justice Periante.
That as of October 25th, from their point of view, there's an ongoing contract still.
The contract was still open.
And they expected King to come to further promote this project.
Absolutely, and there had been no...
Under paragraph 14 of the agreement.
Precisely.
Okay, and that's what I was saying. The only thing that if the due diligence period, though, was not extended, then, and they didn't breach first, King didn't breach first, then you would lose the right, if you terminated the contract, to get your deposit back.
Well, if we terminated the contract because the due diligence was open, we have a right to pull back the deposit.
No, I'm saying if it wasn't, if it's in writing, so the judge still can make a determination as to whether King breached the contract while it was in existence and before there was a demand for the return of the contract, of the deposit.
And that's what the trial court found. That King breached the agreement while the obligation to support...
Was that litigated before the 4th District? I mean, was that an issue on appeal?
It was. The 4th District opinions dealt with it rather summarily. It just found that there was competent and substantial evidence to support the lower court's finding of breach, and that's the record and the established facts which are undisturbed.
Why did the 4th District need to reach this issue?
Well,
maybe we're not the 4th District. I understand that, but it seems to me that we still have a problematic opinion out there.
Let me see how you analyze this. So you're saying at the end of the due diligence period that DK was required to offer closing documents, and that was the act that's missing to entitle them to the money, to the deposit.
The addendum requires, yes, at the end of the due diligence period.
Right, that's what you're saying, and you're saying because they didn't do that, then this contract is open, it's proceeding, and by not appearing, that's a breach of that contract.
Well, they didn't perform the obligation.
Right. Well, it's a breach, isn't it? I mean, what is it?
We missed it because this is a friendly question, and it seems like you're not giving us a straightforward answer. Because if we're wrong on this, then I mean this.
Yes,
I'm trying to understand this because it seems to me, I must tell you, it seems to me the 4th District took off on a discussion of estoppel and stuff that may not have anything to do with anything. Is the way you're arguing it. Either there was a contract and one party breached it, or there was not a contract and nobody's breached it, and you put everybody back in the same position. You can't be both. As I'm hearing what DK says, is that you had a period of time in which you needed to have due diligence, and if you don't cancel by that date, then you forfeited your deposit because you didn't go through with the deal. That's what they're saying, aren't they?
Yes, they are saying that.
Okay. Well, and you're saying this is not an estoppel. You're saying that they breached their contract because they had to come forward with closing documents. Therefore, they had not. This deal is still open and didn't show up for the hearing, and therefore they breached it, and you get your money back.
Yes. Let me
Okay,
give you
all
a
right.
friendly, direct answer. Yes, and we did brief the point, and it's an argument, that's a main argument that we're making before this court, that independent of the due diligence period, whether the court finds that the verbal extension of the due diligence period is enforceable or not, EB is still entitled to the return of its deposit based on the independent breach. I know I'm way over time. I'm trying to respond to all the questions. Just getting back briefly to the waiver and estoppel, and I should probably quit while I'm ahead, but I can't resist.
Well, you really need to quit soon because you're 6 minutes over time.
And I would still like to ask my second question.
Justice Polson, answer your question.
Okay, I just want to be sure. The fourth DCA reversed a portion of the trial judgment that awarded your client $500,000 in damages because there was a failure it found for there to be a joint venture agreement, right?
That was what the fourth DCA
And you're not
ruled.
challenging that here?
We did not appeal that to this
Thank you.
court. Just to bring some clarity, and before I sit down.
In 15 seconds.
Okay. We did propose a test, and I think that it would answer a lot of the concerns which Justice Lewis has raised concerning when the doctrines of waiver and estoppel would apply to situations like this under the statute of frauds, where there's a written contract, where there is waiver by the party for whose benefit the term exists that induces reliance by the other party as to some other performance that will be acceptable. That would be a suggestion which we've made for the proper use of the doctrines of waiver and estoppel to prevent the unjust application of the statute of frauds, which DK is advocating today. For all these reasons, we believe the fourth DCA should be affirmed. Thank you.
Thank you.
Justice Quince, if you'll look at page 9 of our brief, we define equitable estoppel and promissory estoppel and explain the distinctions between the two.
Okay, so let me see if I can hone in on what we were just discussing, which is, once the due diligence period ended, who had an obligation to do something?
The due diligence period ended. They did not terminate the agreement. We had the right to demand the $1 million deposit. We demanded the $1 million deposit.
But wait a second, but if didn't you want to go ahead with the contract? In other words, the due diligence period only means that they are losing their chance for them to get their deposit back, but it doesn't mean that the contract's still in existence, isn't it?
It would have been in existence if they had paid the $1 million.
Yeah, it's in existence with the $1 million in your client's pocket.
Yes, but we asked for the $1 million, and the record testimony is that Mr. Markey, on behalf of EB, told the escrow agent not to pay the $1 million.
And that happened before Don King didn't show up.
That happened before the meeting was supposed to occur, and that was a breach of the contract.
And that's why he didn't show
So
up?
Yes.
Is that testimony in the record? He didn't
Yes.
show up because they breached and they
Yes,
didn't get their
because he didn't get the $1 million.
So your argument is that because without getting the $1 million, they were not obligated to come forward with closing documents and all this, which is, as I understand it, his argument is that the contract was going on and that it was your obligation then to come forward with closing documents.
Yes, because we get the $1 million back. That means they are buying the property as is, and therefore we would have been obligated to provide closing documents. They didn't pay the $1 million. They didn't buy the property as is. There was no need for closing documents. One final point, if I may, in terms of the consideration for the extension of the due diligence. And there was talk about, well, what did DK get? What did EB give or get? This is essential. At the time of the discussion on the 11th that I mentioned earlier, the lawyers for Don King said this contract terminates today. The due diligence terminates today. If you do not terminate the contract, they said, terminate the contract, we'll continue to negotiate the joint venture, life will go on, but in accordance with the specific terms of the agreement. If you don't terminate it, we get the $1 million. Now, the reason, and the only reason in this record that they did not terminate the agreement then or at any time after that is not because they were relying on this extension. There is no testimony in the record to support that. The only evidence in the record, and I would ask the court to look at the pages that we've attached, 169 through 174. The only reason they gave was we can't terminate the contract because then we will be in breach of a companion contract with the tri-rail system, because there was a penalty provision in that contract if they terminated our contract. So the reason that Congressman Klein gave for not being willing to terminate the contract was we can't do that because we'll be in violation of a companion contract.
I just want to make sure Congressman Klein at the time was not a congressman.
No,
He's not a congressman now.
no.
Okay, so let's just call him Ron Klein. I mean, it just makes it in the, we can't put him
I'm
in.
trying to be respectful of people that once had a title.
I just
and
think
not.
it gets, we certainly don't want to think of a congressman practicing law, so at the time that
Well,
he's a
what went
congressman.
on here, you wouldn't be, so. In any event, the reason the contract wasn't, I didn't mean that as you're all taking it. Well, I did, but the reason the contract wasn't terminated had nothing to do with the extension of the due diligence. It was a
But
totally separate
isn't that a
reason.
factual finding that somebody made below?
It's not a finding because it wasn't necessary to be found. The Fourth District rejected all of the trial court's decision, but it is the only fact in the record as to why it wasn't terminated. Thank you all.
We thank you both for your arguments. That's the last case on the docket today. The session of court is adjourned.
All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.